Open this hearing of the Senate Foreign Affairs, Defence and Trade References Committee into wrongful detention of Australian citizens overseas. The committee will be conducting today's hearing via video conference and in person. I am Senator Chandler, the chair of the committee, and I am joined in the room by Senator Cadell. We also have Senator Ciccone joining via video conference at the moment, and I understand Senator Steele-John will be joining us later in the morning. These are public proceedings being video streamed live via the Parliament's website, and a Hansard transcript is being made. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence. Witnesses also have a right to request to be heard in camera. I remind committee members and witnesses who are appearing via video conference and who are not speaking to mute their microphones. I'd now like to welcome our first witnesses for the day, Ms Natalia Kubesh from Redress, and we're hoping to have Mr Geoffrey Robertson KC on the line shortly as well. I understand, Ms Kubesh, that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full name and the capacity in which you appear today?
Of course. My name is Natalia Kubesh and I'm a legal officer at Redress.
Thank you, Ms Kubesh. I now invite you to make a short opening statement, and at the conclusion of any remarks, I will invite members of the committee to ask questions.
Of course. Thank you very much. I'm very grateful to the Senate Foreign Affairs, Defence and Trade Committee for your invitation to allow me to address some of the issues that arise in this inquiry. As I mentioned, I'm a legal officer at Redress. Redress is an NGO based in the UK and the Netherlands that pursues legal claims on behalf of survivors of torture in the UK and around the world to obtain justice and reparation for the violations of their human rights. Over the years, Redress has legally represented individuals impacted by arbitrary detention and state hostage-taking. For example, Redress represented Nazanin Zaghari-Ratcliffe, a British-Iranian charity worker who was arbitrarily detained and tortured in Iran from April 2016 until March 2022. Redress's work on Nazanin's case has included advocating on her behalf to UN special procedures, including the Special Rapporteur on Iran, the Special Rapporteur on Torture, and securing a ruling from the UN Working Group on Arbitrary Detention that her detention in Iran was arbitrary, unlawful, and that she should be released immediately. Redress also supported Richard Ratcliffe, Nazanin's husband, in his engagement with the UK Foreign, Commonwealth and Development Office, including securing the UK's grant of diplomatic protection over Nazanin in 2019, an exceptional step that was formally escalated the matter to an interstate dispute between the UK and Iran. In fact, it was actually the first time the UK had used this procedure in more than a century. More recently, in collaboration with survivors of state hostage taken in Iran, Redress has submitted 2 dossiers to sanction authorities in the UK, US, EU, Canada and Australia, asking them to impose Magnitsky sanctions on 20 Iranian officials involved in Iran's hostage-taking practices. The submissions are based on testimony from victims, including former hostages and the families of current hostages, and expose the deliberate, systemic and escalating nature of Iran's hostage-taking practices, amounting to torture and violations of international law. Finally, Redress has also submitted evidence to 2 related inquiries by the UK Parliament's Foreign Affairs Committee, 1 inquiry on Iran, as well as another one into the UK's handling of state-level hostage situations. The final reports of both inquiries incorporated some of Redress's recommendations, and we have also included these recommendations in our submission to you today. Now, based on Redress's experience working on this topic in the UK context, our submission and the evidence that I will give today focuses on the ways in which Australia could strengthen its framework to deter the practice of arbitrary detention for diplomatic leverage, in other words, state hostage-taking. As I'm not an Australian lawyer and we do not work on Australian case per se, I will not be able to comment on Australian law practice in detail. However, we'll draw on our own experience to make recommendations that might inform improvements in the Australian framework. Having said that, we identified 3 broad recommendations that are focused on recognition, support, deterrence, and accountability for hostage-taking. I'll briefly summarize those to conclude. Our first recommendation is that the Australian government should recognise arbitrary detention for diplomatic leverage as state hostage-taking and call it out in the strongest possible terms when it occurs. The importance of recognition cannot be overstated. It sends a clear message that such practices are unacceptable and that diplomatic formalities will not be placed above upholding the human rights of state nationals. It also serves to repudiate false allegations against the victims and ensures that hostage cases are dealt with appropriately. Our second recommendation to the Australian government is that it should explore taking a more structured approach to state hostage-taking, an approach that is effective at protecting nationals from torture and proactively reacting to risk of ill treatment. As we highlight in our submission, the highest risk of torture occurs during the first 24 to 48 hours of detention, especially in cases of incommunicado detention. As such, an approach that can react quickly is essential. One way of establishing such an approach could be by introducing an independent, well-resourced role within the Australian government with responsibility for handling state hostage-taking cases of its nationals. Now, finally, we urge the Australian government that it should explore whether its legal framework ensures accountability for perpetrators of international crimes that are connected with state hostage-taking. This may include bringing universal jurisdiction cases, as well as imposing Magnitsky sanctions against perpetrator. Given that torture is a significant concern in virtually all hostage-taking cases, the Australian government must recognise that deterring and providing accountability for hostage-taking also means deterring torture, and so to fulfil its obligations to uphold the absolute prohibition of torture under international law. Thank you very much.
Thank you very much, Ms. Kubesh. We have Mr. Robertson online now. So, Mr. Robertson, for the Hansard record, could you please state your name and the capacity in which you appear today? I think you're on mute, Mr. Robertson. Mr. Robertson, you're on mute, so you might need to unmute your microphone, if that's all right. Still on mute.
No, go on.
I think you're off mute now.
Can you hear me now?
That's right, yes. Thank you, Mr. Robertson.
Good. Well, good morning, members of the committee. It's good evening here, very late evening, but nonetheless, I'm very grateful for you giving me the opportunity. I've made written submissions, of course, and I shall summarise them now. There's a lot of legalistic talk among your papers of arbitrary detention, but arbitrary is a phrase I try to avoid because it's a legal phrase which has different meanings to different people, different meanings to different lawyers. And what we're talking about, surely, is wrongful detention of Australians. It's better to talk of that, not only jailing innocent Australians for political purposes, but imprisoning them after unfair trials or unlawful arrests, or guilty Australians who face a sentence of death. All of these cases should attract special attention from the Australian government because the ill treatment and unlawful treatment of individual Australians by foreign states not merely inflicts cruelty on them as individuals, but is an insult to their country because it displays contempt for international law. So for that reason, the government must get involved in these particular cases. Firstly, I'd make the point about the pathetic wording of the Australian passport. Most countries try to impress on border guards or officials that may arrest their nationals that those nationals must be protected under international law and that the government will take any unlawful treatment of their nationals very seriously. The wording of the Australian passport does not do that, and I've suggested ways in which it could, and indeed should. It makes some reference obscurely to the power of the Governor-General, a personage who will strike no fear at all in the breast of a fascist border guard or a secret policeman. It should leave that individual official who takes control of an Australian's passport no doubt that they will be held accountable if that Australian suffers any inhumane treatment. Much of the impetus of the committee is on hostage diplomacy. This is a primitive act, not of real diplomats, but of barbarians, and Iran is the worst offender. Russia and China occasionally, but if they can get away with it, so can smaller countries. And a particularly egregious example at the moment is Azerbaijan, which is silencing climate critics in the lead up to COP24, which it should never been allowed to host. But we must start using Magnitsky laws against the perpetrators of injustice against Australians. DFAT, I'm afraid, is pretty hopeless. The Andrews Committee, to which I gave evidence, recommended that Australia should apply sanctions for proven breaches of human rights. But this objective was undermined from the beginning by DFAT, which has insisted that Magnitsky sanctions were, and I quote, a foreign policy tool, nothing to do with human rights, but simply an useful tool for Australian foreign policy. And that mistake, because Magnitsky sanctions are, if anything, a human rights tool, has led it to withhold sanctions from people who should obviously have them imposed upon them. Classic example is the brutal judge who sentenced Ms. Moore-Gilbert, the innocent Australian academic, to years and years. I think she served 6 years of wrongful imprisonment. He's the judge who hands out many of the death sentences in Tehran. And if anyone deserves Magnitsky sanctions, it's him. The failure of Australia to impose them on the very perpetrator of this wicked injustice against an Australian just shows, I think, how hopeless DFAT has been in using this valuable power to hold officials in other countries accountable. Well, there can be no excuse for hostage diplomacy, and diplomats who represent a state which engages in it could be expelled, declared persona non grata, and the embassy closed. That would be no bad thing in the case of Iran, who seems to have an ambassador who calls for the extermination of Israel. And no bad thing in the case of Russia, whose diplomats are spies who spend their time drinking vodka and selecting the Australian journalists and politicians who will be sanctioned for criticizing Russia's monstrous and illegal conduct in Ukraine. We as a country, I think, have far too much respect for foreign diplomats and their outdated privileges. But so far as reaction to wrongful detention of our citizens, I make 3 recommendations based on acting over the years and since the Ian Gray case in 1988. Ian was a missionary from Toowoomba who faced being executed by firing squad in Mozambique back in 1988, and we succeeded in stopping that, in reducing his sentence and letting him be returned to Toowoomba within a year. But the first point I would make is that DFAT must stop discouraging victims from going public to enlist media support or NGO support. In my experience, actually, most individuals who are falsely imprisoned in foreign countries have their case better advanced by an international media campaign than by our nervous DFAT consular officials who can't do anything often to free them. But DFAT's knee-jerk reaction in every case is keep quiet, leave it to us, we're the experts. But they're not. They put pressure on the parents of detainees not to talk to the media or to protest. And I think this behavior is actually unconscionable. It may serve to protect DFAT from public criticism when it's unable to obtain the release of wrongly detained Australians, but sometimes such criticism is deserved. Now, the second matter I want to take issue with is the routine, indeed the policy refusal of DFAT to provide any legal assistance for wrongly detained Australians. Any of our citizens who is detained unfairly, illegally treated, will have legal remedies in international law, whether by way of appeal to the United Nations Working Group or to the United Nations Human Rights Committee, or perhaps to a regional human rights court, or to relevant UN rapporteurs, or to the Committee Against Torture. It's important that they be advised as to the alternative remedies that they can have, and it's important that they have expert human rights lawyers to present their case. But my experience is that our DFAT officials know very little about the legalities of going to this court or that, and it's obviously a case where they need lawyers. Most of them are available. They give their legal advice for free very often, but DFAT should support them in taking legal action. Apparently, it doesn't, and actually has a written policy against this because they think that encouraging or funding prisoners to take action in international courts is in some way interfering with a local government's legal system. That's nonsense, and it must be disabused of that idea. Going to an international court is not an interference in a local legal system. It is enabling an Australian to take advantage, to use the international legal rights that he or she has as a citizen. And so it's entirely wrong-headed of DFAT to deny this opportunity to those who are wrongly detained. And the third aspect I want to draw your attention to is that wrongful imprisonment, often solitary imprisonment, by an oppressive foreign state is a terrifying and a lonely experience, especially when it goes on for years. The most important succor that a prisoner can have is the support of fellow prisoners who help them despite their own punishment. They are punished very often for helping wrongly detained Australians. And I think any Australian would think that those individuals who suffer by assisting our citizens who are wrongly treated should be helped, should be rewarded, should be offered, if they manage to escape themselves from the oppressor's prison, they should be offered asylum in this country. Yet I'm told that there are a number of people who assisted Kylie Moore-Gilbert in her terrible ordeal. They've escaped to Turkey and they applied for asylum in Australia, but they're given no priority at all by the relevant ministry. And I think Australians would think that was deplorable. And there is a moral duty on DFAT to make sure that the appropriate department, the Minister for Immigration in this case, is given notice of the fact that these people are justifiably and are morally due to our help and support for the support they've given to Australians wrongfully imprisoned. Well, I've read DFAT's submission to this committee. There are really a lot of broadly based generalities, as well as patting themselves on the back, what they call their flexibility, by which they seem to mean their freedom from compliance with any rules. I did notice, surprisingly, that in every paragraph, sometimes every line, they describe the detained Australians as their client. This is very odd. It's a serious misunderstanding of their consular duty to assist victims of injustice, victims of wrongful acts by other states. To treat them as mere clients is to belittle them and condescend to them, and perhaps explain why, part of the reason why, they are denied relationships with lawyers and doctors who could help them. So I think DFAT must recognize, it doesn't in its statement to you, it says confidentiality is assumed to be best to support the client's interests. Well, it is the client who must decide where his or her best interests lie, and if they want the support of an international campaign for their freedom, they must be entitled to that, and DFAT must assist them, not go and warn their parents that they'll never get out if they make a fuss about the ill treatment. That's the wrong approach, and in a number of cases of which I've studied or we've been involved in, it is an approach that has denied them the opportunity that an international campaign or an international court action allows them. So they are the changes in policy that I would wish to see DFAT apply in these cases, not only of really hostage-taking of the kind that I've described in Iran, but cases where wrongful imprisonment has been caused by an unfair trial or an over-the-top sentence. So those cases do require special consideration by the Australian government. DFAT should perhaps have an official who's learned in international human rights law and knows the difference between the tribunals and the opportunities that different tribunals have, and can advise the detainees of the right approach. But in any case, it must be accepted that wrongful detention of an Australian citizen, contrary to international law, is not just an appalling treatment for that person, but is an insult to Australia and requires the strongest response. Thank you.
Thank you very much, Mr. Robertson. I have some questions for our witnesses this morning, and then after I've asked mine, I will hand the call around to my colleagues who are here for the committee meeting as well. First of all, to Ms. Kubesh. I note your submission mentions the work that Redress has done with survivors of hostage-taking in Iran, and you pointed to some of that in your opening statement. Could you please detail the difficulties you encounter in these cases specific to the IRI regime?
Yes, of course. I think the work you're referring to is some of the work we've recently been doing in relation to collating evidence for the purpose of Magnitsky sanction submissions. Is that correct? Is that the reference you were referring to in our submission?
Yes.
Yeah. Well, I think some of the challenges we've been facing we have been facing some challenges in terms of the evidence collation, and then also finding the political appetite among sanctioning jurisdictions and actually acting upon the evidence that we've collated. In terms of the evidence collation, some of the challenges, so our project specifically aimed at trying to identify perpetrators of hostage-taking across the different stages of the hostage-taking process, which involved the initial interrogation and arrest, the court processes, the treatment in detention, the state propaganda through state-owned media, as well as government officials involved in ultimate negotiations. And some of the struggles that we have faced specifically is in terms of identifying the perpetrators at the earlier stages, the ones who are actually in charge of interrogations, the ones who commit acts of torture during incommunicado detention, because individuals are left in extraordinarily vulnerable positions. They're often blindfolded. Individuals use different forms of names, so we've struggled in actually identifying some of these individuals. We've overcome some of these challenges by actually bringing together a really big group of survivors and making sure that we piece together the evidence based on their testimonies, and so slowly come up with the picture of perpetrators. What this has meant is that we ended up having, so far we will have 3 very detailed submissions showing the types of abuses they're exposed to and identifying perpetrators of hostage-taking. That includes low-level officials, that includes mid-level officials, and that includes high-ranking officials, including the judge that was just mentioned. Having said that, despite the strength of the evidence, we have found very different levels of engagement with governments on the sanction file. From the Australian government, we've submitted both files and we didn't receive any response or any follow-up engagement, despite some of the evidence being contributed by Australian victims of hostage-taking. I think this level of engagement has been not only extraordinarily frustrating, but also undermines accountability processes, and from the perspective of victims has compounded feelings of powerlessness and helplessness, as it just shows a complete lack of interest. 2 sanctions were imposed last year against 2 media officials by the Australian government, and in a welcoming development, those designations did refer to their involvement in harassing dual nationals and being involved in the broadcasting of false confessions, but we would like to see much more action, given that they are sitting on the evidence that we have provided.
Sorry, just to clarify, Ms. Kubesh, so you provided I was just about to use the expression dossier, Senator Cadell, but a file of evidence to the Australian government in relation to individuals within Iran who could potentially be sanctioned by this government, and you haven't received any recognition from the government that that information has been received?
We received, I think, the automated response. I also know that Kylie Moore-Gilbert has also previously advocated for the imposition of sanctions in response to our file, but we've not had any further engagement. And those are 2 very detailed dossiers. We are talking about 90 pages one and 70 pages the other, identifying in each case 10 individuals, which makes it 20 individuals in total.
Mm. And I'm guessing that these individuals that you identified have not since been sanctioned by the Australian government?
Only 2. Two I mentioned were 2 journalists involved in the broadcasting of false confessions of dual nationals, including Australians.
Thank you. We know that the Islamic Revolutionary Guard Corps obviously engages in terrorist activities and actively funds and trains extremist groups abroad. But from your understanding of what is happening within Iran, does the IRGC have a significant role to play in the arbitrary detention of foreign nationals?
Yes, based on the evidence collated, it's very clear. It's very clear that they're basically overseeing all the cases. Mm. The arbitrary hostage-taking, happens at the level of the Ministry of Intelligence as well as of the IRGC, but most of the cases go through the Revolutionary Guard Corps, so they're central. Yeah.
You said in your opening statement, Ms. Kubesh, that you talked about the importance of recognising cases of wrongful detention and hostage diplomacy, and I think you used the words that importance couldn't be overstated. Is there a case to be made that by publicly calling out a regime which uses hostage diplomacy is in effect a measure that Western democracies could take to prevent the practice to start with?
I think the recognition is a crucial step in accountability efforts, and that's something we've been advocating for and that our partners and survivors of hostage taking have been advocating for. In terms of accountability specifically, I think the US case demonstrates that recognition does allow for the development of specific legislative and policy frameworks. So as I mentioned, the US has formally recognized state hostage taking, and on the back of that enacted the Robert Levinson Hostage Recovery and Hostage Taking Accountability Act. This act, as I'm sure you're aware, allows for the imposition of sanctions on perpetrators of hostage taking. And the idea behind the sanctions is to deter hostage taking by attaching a cost to the practice and also providing a form of recognition and accountability. So recognition really should be the first step in any accountability effort. Mm-hmm. It could also trigger criminal prosecutions in different regimes. In the UK, for example, hostage taking is a universal jurisdiction crime.
Thank you very much. Ms. Robertson, I just have a couple of questions for you as well. Do you think that governments have been using sanctions selectively to avoid upsetting regimes like the Islamic Republic in Iran?
I think so. We know that is the only conclusion, the only inference one can draw from those regimes that they are sanctioning and those regimes that they are not. If you look at the background to the Magnitsky laws, and I've written a book about them, you'll see that they come about because there are certain officials who are hand in glove or are part of an oppressive state who have been the direct perpetrators of, in this case, wrongful imprisonment. Now, judges were the first to be sanctioned in the original 2012 Magnitsky laws that came to pass in America, because judges and prosecutors do the work, they do the dirty work of the state against their own ethics in cases where they are bound to be independent and are meant to be objective. So, and they're also, of course, quite wealthy. They go abroad, they want to send their families abroad to study at other universities. And so they're good targets. They are worried by incurring Magnitsky sanctions, and yet they don't get sanctions. And I use the example of the Judge Sabatini, I don't know how to pronounce his name, who passes all the death sentences in Tehran, is a monster who found Kylie Moore-Gilbert, who was palpably innocent, guilty and jailed her for 10 years, jailed a couple of obviously innocent Australian backpackers indeed. So be the first to be sanctioned if DFAT had any real understanding of what Magnitsky laws are about. But they quite openly, brazenly, in my view, say, oh, they're merely a tool of our foreign policy. They're not a tool of justice and of human rights, which they should be and which they've always been envisaged as being. So in answer to your question, I do think there is that danger that if they are seen as a tool of foreign policy merely, that they cease to be a tool of justice.
Mr. Robertson, in your experience, have you seen any examples of countries that have good processes, legislative policy or otherwise, in place to identify where one of their citizens has been wrongfully detained and then being transparent that this is what has occurred?
Well, it's difficult sometimes to know. The famous case, of course, of Beverly Griner, the basketball star, who was arrested quite properly by the Russians for sneaking in cannabis oil, was then given a horrendously lengthy sentence, at which point you think that someone in the Kremlin envisaged a different fate for Ms. Greiner than the law provided. And then, of course, it turns out that she's offered up as a popular substitute for Victor Bout, who killed thousands by his arms deal and is a far more dangerous person to the world and to the United States. But yet it was the popular support for the basketball star that enabled her to be seen as a hostage who could be swapped or bound. And that is an example of the difficulty of, there was no way America could protest when Greiner was first arrested, because she was properly arrested. She only became a subject of hostage diplomacy once she had been heavily sentenced some months later. And it's difficult to decide. Even Australian journalists who've been picked up and kept in prison in China, that is, the Chinese tend to be paranoid about journalists probing their national security issues, and they have for many years been locking up Australians for this. And it's difficult to say that they've deliberately been arrested to use in hostage diplomacy, or they're arrested simply out of paranoia about national security, and then perhaps subsequently being swapped. So it's not easy for states to decide, but that's why I prefer not arbitrary detention, but wrongful detention.
Thank you, Mr. Robertson. Senator Ciccone, Deputy Chair, you have the call.
Thanks a lot, Chair, and good morning or good evening to everyone, depending on what time zone you're in around the world. A couple of questions for Redress, if I could start. Wanted to ask you, what access or influence do you think a permanent special envoy could provide that's not possible through, I guess in the Australian context, a ministerial or senior official engagement?
Yes, of course. I think, well, there are a number of points. On the one hand, having a permanent envoy that's potentially similar to SPEA in the US ensures that there's a permanent fixture, which is would hopefully be an individual with the relevant expertise, the relevant seniority to have direct access to the relevant authorities, and would not be subject to diplomatic rotation. So it would, on the one hand, be a very consistent, experienced role that could be overseeing these cases. It could also ensure that there's greater coordination among different government departments, which is essential in cases of hostage taking, which really fall outside the consular cases and bring with it a lot of political dimensions. It would also probably be better able to assess accountability routes, for example, the imposition of Magnitsky sanctions, and be directly tasked with assessing evidence on those lines. Another element that would be crucial, especially from the perspective of survivors, is that it opens up a channel of consistent and accurate information sharing with families to make sure they're being kept updated about the cases. In the case we have worked on, that's a real source of concern, hopelessness, helplessness. Is just a lack of transparency and information on the cases and how they're progressing. And it could also be more proactive in really identifying countries of concern where hostage taking is more prevalent and providing advice to make sure that individuals are not being put in the position. But I think the consistency in the experience and the coordination among government officials is really what is key and would distinguish it from current processes.
Yeah, and I say that in the context of the US approach. What aspects of the US approach do you think could most be useful to be adopted here in Australia in our system without sort of creating new layers of bureaucracy?
Well, I think that relates to the first question you asked. It is the creation of an independent office, either an official or a team that is dealing specifically with hostage-taking cases, ensuring the coordination among government officials. I appreciate it's a new role, but if a new role ensures streamlined positions, then I think that would reduce bureaucracy and would make sure that those cases are dealt with specifically with those who have expertise and therefore able to react to it more quickly.
In a previous hearing, we also discussed potentially the support this envoy could provide families of the individuals, whether immediate or over the medium to long term. Is that something that you'd want to make some comment on?
Yes, of course. I think on the one hand, it touches on what I said at the beginning is one key part of support is, of course, ongoing forms of information and making sure that families are being kept in loop, and then forms of support are being provided for the families at the beginning of the process, during the process, and even afterwards is essential.
Yeah. Are you familiar at all with some of the Australian committees that we have here that deals with some of these situations, like the complex case committee? Are you aware of that?
Briefly, but I probably would feel uncomfortable.
No, that's all right. No, it's all good. Look, my other question I also wanted to pose to you was that is there not a risk a government's public pronouncement of a citizen's arbitrary or wrongfully detained situation could potentially reduce the space for any diplomatic engagement between governments about trying to release certain individuals?
Yeah, I think that is a counter-argument that is made a lot, but I may also defer to my other panelist who touched upon it earlier.
And I will ask Mr. Robertson that same question too, which I'm sure he'll take on note, but I thought I'd just ask you the question.
Yeah, well, I think on the basis of the experience that we've had is that that has not been the case, and that whilst it is normally the excuse being used, in a lot of cases actually the public pressure that comes from making the cases public has been more effective in having engagement in the case and making sure that action is being taken. So I appreciate the concern in theory, but I think in practice we've seen that the public announcement has been more effective in resolving cases.
And just last, I just wanted to ask, what aspects of the Leveson Act do you think could be more effective?
In the Australian context?
Yeah.
Well, I think, again, as I said at the beginning, I think having the creation of a special unit or department or a special unit or person overseeing the cases is crucial. And then also, having worked on sanctions in this context, having a specific legislation that encourages imposition of sanctions and creating that space, I think, is also really important because it identifies a form of accountability and encourages government to use it.
And to pick up one thing there from that, in terms of the global context then, what system do you think actually is the most effective at dealing with these situations? Do you think the US model, other European models?
I think for now, the US model is, based on our experience, the US model is the most advanced. It's not perfect, but it's the most advanced. And if we're looking into a model that's capable of streamlining processes, acting effectively, and bringing together different government departments, that's so far the most advanced version.
And do you think also because it's the US that it has a bit more gravitas attached to it, not so much the system that they've got?
Well, I think if you're asking me if it has a gravitas because it's the US in terms of reputation, I don't think so. I think the process in itself is the most advanced. But of course, the US, having the power it has as a country, will have a different sway on certain hostage negotiations. But that's not something I can comment on.
Yeah. All right. Look, Anna, thank you for making the time this morning. Now, Mr. Robertson, can I also ask you that other question I just put on notice to you before, to the other panellist, about the risk that if a government does go out publicly, does that risk then any chance of us being able to negotiate or engage with these foreign countries in a more diplomatic manner? And you're on mute, by the way, too, mate. There we go. We're back on. There we go.
Right.
Excellent.
Well, that's always the excuse used by DFAT and told to worried, frantic relatives and parents and so on. Don't be quiet. Don't let the media know. We can handle it. We're the experts. In a state like Iran, that's a blatant lie, because Australia is given no time of day and diplomats have no power unless, of course, they come offering money. So I've seen numerous cases. There are a few in your papers. I think the case of the Australian academic, Kylie Moore, and the case of the Australian filmmaker, played tennis with him in the past, James, who was detained in Vietnam and clearly innocent. I think in both cases, the Australian government would have been justified in going full tilt, as the Americans do. But, of course, some cases are questionable. Some Australians do smuggle drugs and get involved in revolutions and the like, and so there may be some time before a clear view can be taken. But if it wants to be clear, can have an inquiry. There were Nazanin Radcliffe, the British Iranian who was held with Kylie Moore-Gilbert, I did an inquiry into the allegations against her for Reuters, her employer, and they were nonsense. But the government was nervous about making an attack on Iran. I think that attacks on Iran have to be made to stop the hostage diplomacy that it uses if ever one of it wants to get back one of its citizens, one of its secret service people who've been arrested and convicted in other countries. So it depends, I suppose, is the inevitable answer. But in cases where it's clear that there is no case against the Australian, that they've been used for purposes of hostage diplomacy or simply for purposes of getting money, or in some cases, I have to say, and I've done cases in Kuwait, in some of the Middle Eastern countries where people are Australians are subject to unfair trials and for reasons that have to do with malice and commercial hatreds, end up with long prison terms. So there are different factors involved, but I think there are cases where the government should go out and defend publicly and bring the breaches of international law to the attention of international courts, and should support those campaigns for the release of innocent Australians.
Okay, well, and thank you for that. Now, I'm just mindful of our time here, but can I just ask you one thing? Out of interest, I was reading your submission, as I do with all the witnesses, but you mentioned about Australian passports and suggesting some wording should be added to Australian passports to impress on foreign officials about how serious the government takes the issue of wrongful detention. Can I ask, why did you mention that? Is there other countries? Do other countries do this?
Yes, they do.
Do you think it's effective? Like, someone in Iran, are they going to look at our passport and think, well, just because the Australian government has some words in the passport, they're going to change their habit? But I was interested to know why you popped that into your submission.
Well, the first thing that an Australian who's being wrongfully arrested has to do is to pull out their passport. And where the passport actually sets out their international rights to be treated humanely, to contact the embassy at this number, and so forth, and shows the border guard or the customs official or whoever is behaving oppressively, that may have some effect. But to show a passport which refers obscurely to some figure called the Governor-General, who, with the help of Queen Elizabeth, actually, passports haven't been updated, will do whatever is necessary, is really quite comical to think that that will have any effect. And if other countries certainly make clear, and I think it should be made clear, not only to those who may treat Australians inhumanely, that the Australian government will in due course hold them accountable, but also to give some, if you like, support to the Australian citizen themselves, who is faced with this terrible prospect of detention, often in solitary, for years, maybe, give them some comfort that the Australian government will go out and backfill them. So that's the two reasons why I believe that change in what is on our passports.
Which other countries do this?
Well, I've just noticed it. America, I believe. But it's something that I've picked up from time to time, that some governments go out of their way to warn those who deal with their citizens that they must be dealt with in accordance with international law.
Oh, thank you very much, Mr. Robertson. Chair, I'll return the call back to you.
Thank you, Deputy Chair. Senator Cadell, you have the call.
Thank you, Chair. Just a couple of questions. Ms. Kubesh, you handed over 2 dossiers of 10 people that you think should be subject to sanctions. You mentioned 2 have. How many of those 20 were members of or linked directly to the IRGC?
I would need to double check the exact number, but the ones that tend to be direct members, I think it would be around 10 potentially. So the ones we usually put forward, individuals or entities involved in interrogations, court processes, detention, media, and state negotiations, and the IRGC. Depending on the case, whether it's under the authority of the IRGC or the Ministry of Intelligence, would normally be within the initial interrogation with the interrogators and then during the court process in the revolutionary courts. I can get you the exact number, but roughly I would say 8 to 10.
Thank you very much. I saw you nodding in some of the answers to the other witnesses' testimony about when this... there's a stage where, and he gave the example of the basketball in Russia, where an arrest, legitimate arrest, becomes wrongful detention or hostage-taking when punishments, or there is a transition where we can look at that. That's when it becomes a human rights abuse, isn't it, rather than a legal process? When process is taken away from a person is where it really starts to get into a human rights violation, and especially when it's systematic in some regimes.
Well, I think it would really depend on the case you're looking into, because the human rights violations can start way earlier, and the cases we've looked into in Iran, the cases start really from the moment of the arrest they can start as quickly as I mentioned in my introduction. I think, for example, the risk of torture is the highest during the first 24 hours of following the arrest in detention. So I think when the human rights violations start and what the human rights violations are really depend on a case-by-case basis. And in hostage-taking, including in the context of Iran, they are significant, and they include a multitude of different forms of torture and ill treatment, and it's just consists of a numerous different violation, but also in itself amounts to a form of torture.
Thank you. Mr. Robertson, something interesting you semi-implied, I may be reading more into it, is that the DFAT, and I think all the other senators have questioned this, DFAT's requesting of the families or those close to it is almost, the families are almost subjected to their own duress to silence them. And am I reading that you think DFAT has more self-interest in that than, to quote their term, their client interest?
Well, that's an inference that can be drawn, that this idea of keeping quiet, the visiting parents, who are often people who are not familiar with international matters and may be very humble people who are told we're the experts, we know best, your son or your daughter must not complain about their treatment. We will get them out in time. And the time passes, and of course, Australian diplomats have no power to get them out of places like Iran. So my concern is just that this knee-jerk idea that, and I don't necessarily suggest that there is any self-protection purpose, although it does have that side issue or consequence, but it is simply wrong for DFAT officials to think that they are the only way, and they have to realize that there is, beyond DFAT, a whole area of international NGOs, international media that bring home in a world which is increasingly conscious of human rights abuses, a world that is receptive and can put all sorts of pressure on countries to change, whether it's cutting back their aid supplies or refusing to supply them with fighter aircraft, whatever. It is significantly, I think, available, and DFAT should encourage, in the appropriate case, international campaigns for release, should encourage, in the appropriate case, international and the taking of the case to international courts, which can judge the country objectively, and by giving judgments, as judgments have been given in many detainee cases now, can give more power in the end to DFAT officials when they lobby for the release of individuals. I would like to say, quite apart from that, that the problems of giving testimony in the early hours of the morning afflicted me, and I forgot the name of James Ricketson, who made submissions very much worth reading to your committee about his anger with the way DFAT dealt with his case. And of course, you have Kylie Moore-Gilbert's submissions, and I've indicated the pages of her very readable book that would be worth your reading on DFAT's attempts to suppress her relatives and talking about her as a client, because she makes clear that they didn't behave to her as they should have as a client by taking her instructions, because she wanted to go public very much with the support, the international support that can derive from going public.
Okay, thank you, Chair. I note the time, so I might put a couple of questions on notice.
Thank you, Senator Cadell. I just have one more question for both witnesses to respond to before we send you off, and that is recognising the way that foreign regimes use hostage diplomacy in an attempt to leverage certain policy outcomes from the government from which the hostage originates, but in this instance we will use the Australian government as an example. Do you believe that hostage diplomacy is a form of foreign interference? Mr. Robertson, did you want to respond to that one first?
Oh, very much so. I believe it's a crime against humanity, and it breaches all sorts of rules of the Vienna Convention and conventions we have about diplomatic behavior. These are not, it's wrong to call it diplomatic hostage taking. It's got nothing to do with diplomacy as properly defined. And there is a convention, a lot of your submissions refer to it. Canada took the initiative when China quite brutally and brazenly responded to the rather over harsh, I must say, extradition request that America had made of Canada, and Canada, instead of releasing her on bail, put her in jail, and immediately 2 innocent Canadians in Canada were arrested and charged with all sorts of offences of which they weren't guilty and kept there until the extradition proceedings against Ms. Meng had ended. That was blatant. And as I say, it's not fortunately been repeated other than by Iran, where in a case in which I testified for the prosecution involving the prison exterminations of radicals and Marxists in 1988, one of the hangmen was on trial and was convicted, Hamid Nouri, and he was jailed for a long period, and Iran responded by arresting a couple in Sweden, and Iran responded by arresting a couple of people of Swedish nationality in Iran and holding them as alleged prisoners. But of course, judges in that country are simply puppets of the state, and they were held until the Nouri was returned to Iran, and he was treated as a returning hero. But that was, it seems to me, a dreadful thing for Sweden to have done. But you have to accept that hostage diplomacy works because politicians are nervous that the public will want their citizen returned from durance vile, rather than, or at the expense of, returning someone who's been rightly sentenced to long periods of imprisonment because they are murderous. Victor Bout is another example. So I think that where countries engage in hostage diplomacy, we should actually bite the bullet and close their embassy, expel them from the country, declare them persona non grata, the sort of thing that is done by diplomats in Latin. But why we should have what benefit we get out of having an Iranian embassy in this country is unclear to me and should be discussed, because it is time that we considered booting out Russian and Iranian diplomats or as agents and representatives of the crimes of their country.
Thank you, Mr. Robertson. Ms. Kubesh, do you think that hostage diplomacy is a form of foreign interference?
Yes, I agree. Hostage taking is a systematic human rights issue that undermines the rule-based order and turns innocent individuals into pawns in a political game of chess. Hostage taking is also currently flourishing in an environment of impunity as perpetrators exploit vulnerabilities of the individuals detained. The fact that it flourishes is perfectly demonstrated by Iran, which is now increasingly moving also into policy of executing those dual nationals arbitrarily detained. And if this is left unchecked, it could further transform in a new form of escalation under hostage-taking practice. Now, all of this to say that the absence of a comprehensive strategy for addressing hostage-taking within governments themselves, but also within the international community, leaves innocent civilians vulnerable and constitutes a significant risk for peace and security.
Thank you very much, Ms. Kubesh. And thank you both for appearing as witnesses before the committee today. The committee would appreciate that responses to questions on notice be provided to us by Friday the 1st of November 2024. I'd ask that you now disconnect from the video conference, but if you wish to continue observing the hearing, you can do so through the live stream on the Australian Parliament's website.
Thank you very much.
Thank you.
Thank you and good night.
Good night, Mr. Robertson. I now welcome Ms. Sarah Tuck, who I know was on the video conference earlier. There she is. Lovely. Ms Tuck, I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full name and the capacity in which you appear today?
My full name is Sarah Teach, and I'm appearing as an individual.
Thank you, Ms Teach. My apologies for the pronunciation earlier. I now invite you to make a short opening statement, and at the conclusion of any remarks, I will invite members of the committee to ask questions.
Sure. Good morning. Good night for me, but good morning for you. Thank you for inviting me to participate in this inquiry. As I said, my name is Sarah Teach, and I'm a lawyer based in Toronto, Canada. Together with David Matus, who, as I understand, has given remarks before this committee and other inquiries, I co-founded an organization called Human Rights Action Group, a collective of lawyers working directly with community groups to combat mass atrocity crimes and gross human rights violations. More relevant to this inquiry, though, is that 3 years ago I authored a legislative proposal on the subject of hostage taking, which was co-published by the Macdonald-Laurier Institute and the Canadian Coalition Against Terror, and that latter organization has since rebranded, is now known as Secure Canada. And over the last year, we have worked closely with the Deputy Leader of the Conservative Party of Canada to adapt that legislative proposal into what is now Bill C-353, which was introduced in the Canadian House of Commons last September. It passed its second reading just this past June with broad bipartisan support and heads to committee review in the coming weeks. Wrongfully detaining civilians is a key tactic employed by authoritarian regimes and terrorist groups alike, and that is essentially because the benefits outweigh the costs. Rights-respecting countries almost across the board have limited toolkits for responding to instances of wrongful detention. Existing pressure levers like targeted sanctions are seldom utilized, and another issue seemingly across several countries is inadequate or at least inconsistent support provided to family members of those wrongfully detained. In Canada, family members of those detained are assigned a family liaison officer, and this is an officer with the Royal Canadian Mounted Police who is designated responsible for communicating with the family. While some go above and beyond, others are indifferent or even disrespectful. One example of this is Robert Fowler, who was released in 2009 from Al-Qaeda, described the relevant RCMP officer as someone who bullied the families and criticized others for standing aside and allowing it to happen. Yet another issue is the often interchangeable use of terms to describe this phenomenon. There's hostage taking, but there's also arbitrary detention in state-to-state relations, hostage diplomacy, wrongful detention, unlawful detention. Before solving a problem, it's important to define it, ideally with reference to existing legal instruments. In Canada, with Bill C-353, Canadian legislators are looking at addressing some of these common issues. The bill would enact the Foreign Hostage Takers Accountability Act, which is split into 3 parts. Part 1 enables sanctions to be imposed on foreign nationals, foreign states, or foreign entities responsible for or complicit in the hostage taking or the arbitrary detention in state-to-state relations of a Canadian national or eligible protected person outside of Canada. Part 2 would remedy the inadequate and inconsistent support provided to family members by mandating that the relevant minister, which would be the Minister of Foreign Affairs, provide them with timely information and assistance, including psychological support services. And finally, Part 3 enables the provision of monetary rewards and/or refugee protection to foreign nationals who provide information leading to the release and repatriation of a Canadian held hostage or arbitrarily detained in state-to-state relations abroad. These would be discretionary tools, and they may serve not only to incentivize cooperation, but also to protect those who assist in recovery efforts from potential retaliation by bringing them and their loved ones to safety in Canada. The wrongful detention of civilians is a global problem that ideally should involve a global solution. The importance of global response is clearly understood by Australia already, as it joined the multilateral declaration in February 2021 against arbitrary detention in state-to-state relations. In sum, my recommendation to this committee is to implement solutions to the same problems that plague Canada in this area, broaden the available tools, include the use of sanctions, and ensure consistent and reliable support for family members of Australians wrongfully detained abroad.
Thank you very much, Ms Teach. A few questions from me just to start with. Your submission notes that in recent years hostage diplomacy has become more prevalent with authoritarian regimes like Russia and China and Iran. Broadly speaking, why do you think this is the case?
I mean, in some, I think it's because, as I said, the benefits outweigh the costs. There have been very little in terms of repercussions for this sort of behavior. So if it works, why not keep doing it? And, we see this in time and time again with the failure to impose sanctions and indeed the failure to impose really any consequences at all.
And why do you think Western democracies are so averse to calling out authoritarian regimes who are using hostage diplomacy as political leverage? And when I say calling out, I mean, on the one hand, literally publicly attributing these regimes for engaging in hostage diplomacy, but I guess also going to that question of sanctions or other diplomatic tools that governments could use to publicly attribute this behaviour.
Right, it's a great question, and my caveat is that obviously I'm not in government, so I can't say for sure why exactly they aren't doing this, but my suspicion is that once you're dealing with a specific case, and at least in Canada, this tends to be responded to on a case-by-case basis. And once you're dealing with a specific case, it becomes so highly sensitive to do anything at all that you worry may negatively impact the situation of a hostage or someone wrongfully detained abroad. So this is where I think it's important, and I'm glad that this committee is doing this, to sort of take a step back and look at, overall what kind of law and policy do we need in general, not in a particular case.
And I think as well, and we've heard this from other witnesses in prior hearings, but the point around how difficult it is to do something publicly in relation to this once you have a specific case underway is, I recognise that difficulty, but at the same time, if you, as the US does, as the Canadian Parliament has obviously done with this bill, if you have a publicly available, clear and transparent framework in place that sets out in broad terms how you as a country will deal with hostage diplomacy situations, then that almost circumvents the sensitivity of what happens when you are managing a case, yes?
Yes, exactly. And you hit on something that I was hoping to say in response to one of your questions as well, which is sort of, why Bill C-353 as opposed to, for example, broadening targeted sanctions laws. And one very large advantage to a dedicated piece of legislation, and this is something we discussed in Canada and the conclusion we came to, is that it sends a very clear signal to would-be perpetrators and to government officials. This is exactly what we're going to do in these types of situations.
Moving to the bill now, I recognise that you're not speaking on behalf of the government or the Parliament of Canada, but obviously you have very good knowledge of Bill C-353. What can Australia take from that bill if we were to consider developing our own clear definition of hostage diplomacy and a clear policy framework to deal with hostage diplomacy?
Yeah, right. I mean, it's a great question. I think essentially, almost all of it. The only thing that I would maybe sort of flag immediately as needing to be adapted to the context is the definition of hostage taking, because in the bill, the definition is tied into how it's defined in the Canadian Criminal Code.
Okay. I'm just checking the time, sorry. I'm just making sure I give ample opportunity for my colleagues to ask some questions as well. You mentioned that in the bill, one of the elements that is covered off is the requirement for government to provide some support to family members of individuals who've been wrongfully detained. We've talked a lot about the shortcomings in terms of any government's response to that particular issue, but the Australian government's response in particular as well. So again, what is actually outlined within that legislation to put the onus on government to provide support to family members?
So the language being must as opposed to may is very strong in the Canadian bill. And this is, we thought this was important because of just how long this inadequate, inconsistent support has been going on. And clearly it's a systemic issue in Canada. And from what I've heard in Australia, there are similar issues. So just the lack of a discretion on that point is very critical. And then it's also specifically mentioned that support includes psychological support services. And again, this was a very direct response to, in Canada, we had a 2016 Toronto Star investigation where they interviewed family members of those wrongfully detained Canadians wrongfully detained. And this was a common theme that was outlined, was the lack of psychological support offered.
And just finally from me on the question of sanctions, I note that you specified there was a section of Bill C353 that goes to listing specific sanctions for those engaging in hostage taking. We have Magnitsky-style sanctions here in Australia. How did those two options for sanctioning sit alongside each other? Do you only need one of these options? Is it best to have both of them? How does that balance work?
Right. So, we decided to put this in sort of all in one bill because, as I said, it's a clear signal to would-be perpetrators. It's a clear signal to government. I think the problem with the existing targeted sanctions regimes is that policymakers seem very hesitant to use them in cases that are anything besides really, extrajudicial killings and torture. There's really a reticence to use them with any other type of human rights violation. So, whether or not it could be covered under Magnitsky laws, the fact is that it's not in practice being used. And then beyond that, in Canada at least, our Magnitsky law doesn't allow for the sanctioning of entities, only individuals. We do have in Canada the Special Economic Measures Act, which allows for sanctioning of entities and individuals. I'm not sure exactly the details of the Australian Magnitsky Act, but the way that we framed the bill in Canada, Bill C353, would allow for the sanctioning of foreign nationals as well as entities and foreign states. So it's the widest possible in terms of targets that engage in this behavior.
Thank you very much. And just finally, sorry, I said my last question was my last question, but just following on from that, why do you think governments are so hesitant to use sanctions? It's all very well for us as parliamentarians to legislate a framework, but if that framework isn't going to be deployed and utilised where necessary, it sort of becomes a redundant exercise. So what explains that hesitance?
It's a great question. I wish I had an answer for you.
Very good. Thank you, Ms Teach. Deputy Chair, Senator Ciccone, you have the call.
Thanks, Chair, and hello. Well, thank you for making time for the committee today. Look, just in relation to the Leveson Act, I asked a couple of witnesses earlier this morning here. What do you think could be done to make it more effective? I was hoping you might be able to share some of your thoughts.
Sure. it's a very broad question. I have a lot of suggestions about the Magnitsky Act in general. I will say this, I'm not an expert in the Australian Magnitsky Act. I'm not licensed to practice law in Australia. But some problems we have in Canada that I suspect may be across the board is, number one, this the need for multilateralism. And this is something we see in Canada a lot, that Canada is very hesitant to act on its own to levy sanctions, and where multilateralism can certainly make the imposition of sanctions stronger, it shouldn't be a constraint to start the process of using this domestic law in response to gross human rights violations. Another sort of problem we see in Canada is a lack of transparency in terms of sanctions submissions, particularly by NGOs and civil society organizations. And this is something I come across all the time in my practice, where we'll make submissions, or a client group of ours will make submissions, and it goes into seemingly a black box where no one responds. Sometimes people respond, but there seems to be no rhyme or reason to when we get a response. They never provide reasons as to, particularly if they don't impose sanctions, there's never reasons given as to why. And something that myself and other international lawyers have been advocating for a long time is a formalized mechanism as well through which civil society organizations can provide information to, in Canada, it's the Sanctions Division. I'm not sure what it's called in Australia. So there's lots of room for improvement there. And again, in Canada, the fact that it can only be used to sanction individuals is a serious limitation, because then Canada ends up relying on other legislation, the Special Economic Measures Act, for sanctioning of entities, which just lends itself to a quite confusing and internally inconsistent sort of process as between the multiple sanctions regimes.
Yeah, and thank you for that. With aspects of the US's approach, do you think what they have in terms of their system on how they deal with people who've been wrongfully detained is one that Canada looks to as a bit of a model of what they think is probably the best in the world at the moment? And are there aspects of it that, you know, Australia should probably look at to incorporate, but without sort of creating more layers of bureaucracy? And I'm not sure if you were able to expand on that, but I'd be interested to get your thoughts on how the US's approach would be looked at.
Sure. I mean, the U.S. approach, these criteria I mentioned, it is, I think, and I'm just pulling up my written submissions, at the bottom of page 3, like from the Robert Robinson Hostage Recovery and Hostage Taking Accountability Act, and then it starts the last line on page 3 and goes on to page 4. Those criteria to try to determine whether a detention is wrongful, I think those are quite useful. That being said, the U.S. Act is not a perfect example to follow, I think, for any other jurisdiction. And, you know, one reason for that is that it doesn't really clearly enough, in my opinion, define its terms. And this is something I should have talked about in that paragraph as well. They use hostage taking, what's the other one? They use whether a detention is unlawful or wrongful right in that sentence. I mean, and this is sort of my point again about the importance of defining terms, but sort of that quibble with it aside, I do think those factors are quite strong, and that act as well has a sanctions provision, which was an inspiration to us as well.
Because then I sort of look at the Australian context where we don't have obviously the US style system, but you know, I think have been very successful and been able to release a number of individuals like Gilbert and Lay and Turnell who've been wrongfully detained. And I'm just trying to understand, you know, having a very strict codified regime, does it work, or is it just because, you know, for certain countries, their way of government might require them, or it might be better for them to set up a system like that. But in the context for Australia, where there's a bit more flexibility with our ministerial and departmental engagement, that maybe at the end of the day gets the outcome that we all want, which is to return these citizens home safely. And I'm not sure how familiar you are with our systems, but is there not, I guess, some risk about trying to have a very strict codified regime in place that might also backfire or work against?
Yes, I'm sure. I'm sorry. Yes, I think the risk of, like, this is why as well for our bill in Canada, we were very careful with, you know, what was a discretionary tool and what was mandated. And the only section that has this mandatory language is the support for families. And that's because in Canada, it's been such a deep and systemic problem. And every other part of the bill is full of the word may. So in that sense, and this is, you know, we had the same discussion in Canada, and this is why we chose that language, so that it wouldn't have any sort of hampering of flexibility. So again, with the caveat that I'm not an Australian barred attorney, and I don't know how legislation is drafted in Australia, perhaps that would apply to Australia as well, in terms of just, you know, if the tools are discretionary, you know, would that mean it doesn't hamper? And I would hope so.
Oh, who knows? Maybe one day you might want to come to Australia. Can I also ask you, in terms of the other aspects of the proposed Canadian Foreign Hostage Taking Accountability Act, and I know you had a discussion earlier with the chair, but I'm just wanting to know what aspects of it could be improved to make it a better piece of legislation that could be more effective?
It's a great question, and this is good prep for a committee hearing in Canada in the coming weeks. I think.
Well, hopefully they're watching.
Yes, I expect it. I think these criteria from the U.S., and this is something I flagged in my written submissions, and again just now, I think having criteria to help guide a determination when a detention is wrongful is something that could always be used to improve. Now, whether that needs to be part of Bill C-353 or if that can be done as a matter of policy, you know, I'm not sure it necessarily needs amendments to the bill, but, you know, either way, I think that that framework is useful. And, I think that's sort of my one idea for improvement, actually. And beyond that, I mean, there was one piece of part 2 which didn't make it into the final form, but this was the creation of a family liaison center in Canada. And that's something that, maybe we can or should revisit. I think that's worth Australia considering as well.
Yeah. And just one final question. In terms of the Canadian context, given that I think our systems of government might be very similar, given your foreign minister has powers to be able to, and their department be able to negotiate and deal with rogue states about trying to return citizens, or do they need to go back to a committee or a parliament or to the parliament for approval, or do they have full powers to be able to return?
I'm actually not sure. I believe they have full powers, but I may want to take that question on notice and provide you with an answer afterwards.
Sure, that's all right. Thank you. All right. Thanks a lot, Chair.
Thank you very much, Senator Cohen. Nothing from you, Senator Cadell. Very good. Well, thank you very much, Ms Teach, for appearing today. I know it was the evening your time, so thanks very much for allowing for the time difference. I think you did take a question on notice from Senator Ciccone just then, so we would appreciate a response to that by Friday the 1st of November 2024. I'd ask that you now disconnect from the video conference, and if you wish to continue observing the hearing, you can do so through the live stream on the Australian Parliament website. Notwithstanding that, the committee is about to break for morning tea and will resume at 11 a.m. local time. Reconvene. And I now welcome Ms Kylie Moore-Gilbert from the Australian Wrongful and Arbitrary Detention Alliance. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your name and the capacity in which you appear today?
Hi, I'm Kylie Moore-Gilbert, Director of the Australian Wrongful and Arbitrary Detention Alliance.
Thank you, Dr Moore-Gilbert. I now invite you to make a short opening statement, and at the conclusion of any remarks, I'll invite members of the committee to ask questions.
Hi everyone, thanks so much for inviting me to speak to you today, and I'd like to thank the committee for instituting this inquiry. The Australian Wrongful and Arbitrary Detention Alliance has been lobbying for this for some time, and it's a really, really important step to reforming the system, a system that's, sorely in need of reform in our view. I'll be appearing today as the director of A-WADA, but also as a former victim of wrongful detention myself. And I'm also a political scientist who's currently conducting academic research in this area, so I kind of wear several hats here, and I'm happy to speak to any aspect of that in the Q&A afterwards. I'll first discuss my own personal experiences and then move on to A-WADA's recommendations as seen in our institutional submission. As you know, I spent 2 years and 3 months wrongfully detained in Iran between 2018 and 2020. I received a 10-year prison sentence and was ultimately traded by the Australian government in a prisoner swap deal for 3 convicted IRGC terrorists. Personally, the impact of this on my life has been devastating, and it's still ongoing. I lost my marriage, I lost my career, my relationships with members of my family have perhaps been irrevocably damaged as a result. And in many ways, it's harder now than it was when I was first released. I spent more than 10 years training as a political scientist, specialising in the Middle East, learning Middle Eastern languages, conducting fieldwork in the region. I love the Middle East, it was my passion and still is, and my arrest destroyed my career. I was unable to return to work in my previous role as a university lecturer, and I did not feel welcome to return to my former Department of Islamic Studies in particular. All the research publications I had in the pipeline were pulled during my imprisonment against my explicit instructions, decimating my academic record and my competitiveness for future roles. And this is but one example of many when my agency to make decisions about my own life was taken away from me by those who were meant to be on my side. And I note Geoffrey Robertson mentioned another example of that earlier regarding going to the media and the detainees' right to make such decisions for themselves too. I've come to realise I'll never be able to claw back my career to the point that it was in before my arrest in 2018. And after dedicating so much of my life to that, it's difficult to accept. Despite being subjected to physical abuse, prolonged psychological torture and sexual harassment in prison, I received no support upon my return to Australia. I do not have a close family network and spent most of my first year post-release alone in my house during lockdown, navigating a very difficult divorce. I was taken advantage of financially by unscrupulous actors seeking to profit from my story. And I was also hacked by Iran and had my personal and financial information posted on an IRGC-linked website in the first year after my arrest. I'm still very angry about what happened to me and everything that I've lost as a result of my wrongful detention. And this is what motivated me to start A-WADA and to campaign for reforms to how Australia manages cases like mine, including greater support for detainees who come home. I know I've ruffled feathers in some quarters with my advocacy, but sometimes the system needs to be shaken up a bit in order to achieve meaningful change. I'm haunted by those who have reached out to me with tales of government ambivalence to their incarceration, and by the families of current Australian detainees who feel forgotten and abandoned. I know I was extraordinarily lucky. The government deployed all of its diplomatic resources to get me out, and I'm extremely grateful for that. Otherwise, I would still be in that prison cell to this day. But not everyone benefits from these resources. Who does and who doesn't appears to be the product of an entirely subjective judgment made somewhere within the bureaucracy or by political decision makers. Maybe it's on the basis of which cases seem to be most obviously unjust, journalists and academics, for example. Or maybe it's those advocates who shout the loudest or get the most media attention. This ad hoc approach is characterised by DFAT in a positive light as flexibility or an a la carte approach. However, what is clear is that not having a definition of a wrongful detention case and not having a distinct process to distinguish such cases has meant that many innocent Aussies have fallen between the cracks and have not enjoyed the resources that I did to bring them home. We cannot abandon our citizens to face torture in foreign prisons, and we cannot leave anybody behind. A number of current cases made submissions to this inquiry, and I note that no representative of a current case has been called yet to give evidence. No representative of Robert Pether, Mohammed Munshi, Hassan Askari, Yang Heng Jun, or Gordon Ng. And I assume that this was a deliberate decision. But I'd urge the committee to consider hearing from Australians currently jailed abroad or prevented from returning home by a travel ban at the third hearing. It's important to remember that some of our fellow citizens are facing this injustice right now. They could be being tortured right now as we speak and are relying on us to bring them home and bring their suffering to an end. I'd just like to make a couple of remarks picking up on some of the comments of the previous speakers today, particularly that of Redress, which you were discussing earlier, that dossier or that report, 2 reports in fact, that they submitted to the Foreign Ministry recommending Magnitsky sanctions on individual perpetrators of hostage-taking from Iran. I was involved in drafting, collating evidence that fed into that report, and I personally submitted the report in addition to Redress to Maurice Payne's office when she was Foreign Minister, to Penny Wong's office as well following the election. And in March of this year, I personally handed over a print out of all 100 pages of that report to Penny Wong myself when we met with her. It's very disappointing that there's been almost no engagement with Redress or with A-WADA on our recommendations for Magnitsky sanctions. Australia hasn't sanctioned anybody for the hostage-taking of our citizens under Magnitsky. And, you know, Geoffrey Robertson made the very powerful case earlier for Abul Qasim Salabati, the judge, the IRGC judge, who sentenced myself, but not just me, at least 3 or 4 even other Australians have been sentenced wrongfully by this judge. Including Jolly King, Mark Firkin, the 2 backpackers, Meymanat Hosseini Chaboshi, the ANU researcher, and an Australian citizen who was only sanctioned a few months ago. Was only convicted a few months ago by that same judge in Iran and is in prison today as we speak. So this guy has been, you know, targeting Australian citizens relentlessly, yet we don't even sanction him, unlike our allies and partners abroad. I think this is but one example that shows that what Sarah Teich was speaking about, the need for a Foreign Hostage Takers Accountability Act here in Australia, following the Canadian and American example. You know, there's been long-standing and systemic issues. We've had Senate inquiries into the hostage-taking of Australian citizens in the past, in 1997, in 2011. If you go back and read those recommendations, very little has changed, unfortunately, particularly when it comes to communication with families and support for families and returned detainees. So it's pretty clear that there are deep systemic issues, and having an act of legislation, as in the US and potentially soon in Canada, would really help force through reform where it hasn't, you know, changed thus far in the system. I'd also speak to what Geoffrey Robertson was saying, and Sarah Teich also touched on this with respect to the Canadian Hostage Takers Accountability Act, in that having provisions to reward foreign citizens who help and assist Australia in repatriating or getting access to or helping in prison innocent Australian detainees would be a really interesting measure, a creative measure to pursue. A number of an Iranian family, a mother and son, helped me extensively when I was in prison, and Geoffrey Robertson actually brought that case up in his evidence. It would be great to offer these people humanitarian visa. They're currently being hunted down by the IRGC in Turkey and are at severe risk of deportation back to Iran, yet there's no recognition from the Australian government of that assistance provided also, which is a real shame. I just finished by emphasising a point that Sarah Teich also made in response to Senator Cicconi's excellent question about whether or not a more codified regime might undermine flexibility in the system, and that, I guess, speaks to DFAT's submission to this inquiry. You know, right now our system isn't working. For every successful case that's been brought home, there are others who languish in prison, and I've named some of them earlier. And even those of us who are brought home, we could have been brought home earlier with a more expeditious response from the get-go following a wrongful arrest. So flexibility is too often cover for incoherence and subjectivity. Instituting a senior expert role not subject to diplomatic rotation, which is crucial in my view, to manage cases does not reduce flexibility. They could be provided with a full suite of flexible tools to tackle this phenomenon, to be used in accordance with their own discretion and expertise, which is already what's happening in the Complex Cases Committee and DFAT. So I think that we are calling in A-WADA as probably our primary recommendation, and we've made about 9 of them for that role to be instituted. But most importantly, it needs to be a very senior person appointed for a fixed period of time that is not subject to diplomatic rotation and has that very, very high level access to the Prime Minister and Foreign Minister. So I'll conclude my remarks there and happy to take any questions about my own experience or A-WADA's institutional submission.
Thank you very much, Dr. Moore-Gilbert. I'll start off with questions, but before I do so, I would like to advise that representatives of the media have requested permission to film and take photographs of the committee's proceedings, and the committee has agreed to this. I remind the media that this permission can be revoked at any time, and the media must follow the direction of Secretariat staff. If a witness objects to being filmed or photographed, the committee will consider this request. The media are reminded that they are not able to take images of senators or witnesses' documents or of the audience, and copies of Senate Resolution 3 concerning the broadcasting of committee proceedings are available from the Secretariat. Thank you for your cooperation in this matter. Dr. Moore-Gilbert, I wanted to first ask you some questions about your specific case. At what point did the Australian government recognise that you had in fact been unlawfully detained?
There is no process for recognising that anyone's unlawfully detained in Australia. There is no even definition of what an unlawful detention constitutes. So as far as I'm aware, whilst ad hoc sort of off-the-cuff remarks were made by various Australian politicians saying that my detention was unjust and farcical even, I don't think there was any formal categorisation at all, as in any other case represented by A-WADA or otherwise.
And in your opening comments, you referenced that you felt that yourself and others could have been returned home sooner than you were if there was a more expeditious response to individual cases as effectively as soon as the Australian government becomes aware that one of their citizens have been detained overseas. So what decision-making process do you see as being really clear to make that determination? And I don't want to preempt your evidence too much, but I'm assuming that from your own perspective, that the government wasn't in a position to make that determination early on once you were first detained.
From what I've seen surveying all Western governments' responses to this, not just Australia's, is that most governments are reticent to call out an arrest as being wrongful until the judicial system of that country has gone through the motions, convicted the person, and the court process is finalised. For that reason, most countries seem to kind of wait for that eventuality before taking action. That can take years, and the person could be tortured and mistreated in the course of those years. We do have a principle of non-interference in other sovereign countries' judicial affairs, but we need to recognise when some of these countries are nasty authoritarian regimes that do not have free and independent judiciaries. Keeping up the pretense that they are like us and that person is being put through a legitimate court process is not really useful to our objective of getting that person home. There is a window of time after a wrongful arrest, but before the person has been entered into the judicial system of the arresting country. Maybe that's a few weeks or months, could even be a year at sometimes, where the person's formally charged and referred to court for trial. There's a window of time where acting expeditiously, creatively, high-level diplomatic outreach might actually be able to free that person before they are entered into the court system. And I'd give you a good example of where the government has actually learnt from this experience and applied it in a subsequent case. And that is the case of the two Aussie backpackers, Jolly and Mark, who were arrested in 2019. They were arrested by the same IRGC squad that arrested me. They were kept in the same facility I was kept in, and it was very clear and obvious to me that they had been arrested explicitly to use as further leverage over the Australian government because the IRGC weren't happy with the course of the negotiations they had entered into over me. So they were just additional leverage. They were muscle flexing by the IRGC. Now, rather than waiting that after that second set of arrests for them to be put into the judicial system, put on trial, convicted, etc., before engaging, straight away, because Australia had appointed an envoy, Nick Warner, at that point to free myself, that envoy straight away sprung into action and managed to free them after 4 months before they had been put on trial and convicted. And that shows you that having one point person who's there, senior, empowered to negotiate and act quickly can actually free someone in those initial months of the arrest before they're even put on trial, if all of that structure is set in place. For myself, I had to wait another year following their arrest in order to be freed, because the system, it's much more complicated once you have someone who's convicted of a crime to try and free them than when somebody's suspected of a crime with, robust diplomacy behind the scenes to try and to pry them loose of that system before everything is concreted in place. So I think that's an example, and there's plenty out of the US where there's a hostage envoy, the Speaker. When an arrest smells really bad and looks super unjust and wrongful in those initial moments, because the Speaker is already in place and already empowered with a suite of tools to tackle this phenomenon, he's able to act quickly to try and free that person before they're put on trial. So I think rethinking our approach here, putting aside the assumption that some of these nasty regimes have free and fair judicial systems, they absolutely do not. So then trying to preempt that trial and get that person free in the initial first weeks or months is a really key approach.
Dr. Moore-Gilbert, I have read your fantastic book that outlines your experience in Iran, but for the committee's benefit and refreshing my memory, what was the period of time between you being arrested and you being formally charged or processed into the judicial system, for want of a better expression?
It was around 6 months.
Yep.
I'm not 100% sure because I wasn't present when I was formally charged, so I don't even know at what point they filed the paperwork or whatever, but I was summoned to court and heard a bill of indictment read to me at about 6 months.
Sorry, Senator Cadell, you just had a quick question on that line.
Just on the timeline thing, what was the difference between your detainment and meeting the first Australian representative from DFAT, or what was that timeline?
It was roughly the same. So I think I met DFAT about 5 months. I met the ambassador to Iran at about 5 months. So before I was read the bill of indictment in court, but after the interrogation phase had ended. Okay. So they thwarted, and most authoritarian regimes do this, they thwart all access, all consular assistance until they've finished interrogating the person, got all the information they want out of you, and then once the process enters the court system, they often allow access. But I was, I'm talking about a tiny room full of IRGC crowding around the ambassador, threatening me in advance. I wasn't able to speak. I wasn't able to do anything. It was merely a proof of life visit rather than any meaningful consular assistance.
Well, what was the timeline for meaningful consular, do you think? Ever?
I did have some meaningful visits. I was never able to discuss my case. I was never able to discuss the prison conditions per se, although I did in an illicit fashion, using coded language at times with the ambassador. Once they had meaningfully entered into negotiations with the Australian government over my release, so in the final year of my incarceration, I was able to have more constructive discussions with the ambassador, but that judge that I mentioned earlier, he actually signed an order banning me from consular assistance because of my disruptive behaviour in prison as a punishment, which is obviously against international law, against the Vienna Conventions, and they're obviously not very troubled by that in Iran. But I was banned from consular assistance as a punishment for a significant period of time, and it was only in the final year of my incarceration that I actually had any real and meaningful engagement with the Australian government at all.
Thank you, Chair.
Thank you very much, Senator Cadell. And some more generalist questions now, Dr Moore-Gilbert, and I recognise that you're appearing here today representing A-WADA as well. The business model of regimes which engage in hostage diplomacy in circumstances where someone has been wrongfully detained almost always involves a pretence that there is a legitimate justification for the detention of that person. What can Australia do to deny those regimes that tactical advantage that they seek publicly by pretending that the detention is for a legitimate reason, while behind the scenes sending the message either explicitly or implicitly that the detention is designed to leverage our government in some way?
I think there's no need to make public statements that might anger an arresting country about, you know, the legitimacy of their judicial systems, right? But in private, we all know which countries have a free and fair judiciary and which don't. It's the same perpetrators again and again. There's actually a relatively small number of countries that take diplomatic hostages. We all know who they are. And when someone is taken in one of those countries, red lights should be flashing immediately before Australia is even across the details of the case. If it's a repeat perpetrator state like Russia, Venezuela, China, North Korea, Iran, obviously, that should be a red flag from the very beginning. But in private, we are, able to make that assessment without necessarily telegraphing it. What we argue in our submission is that a structure needs to be put in place for designating someone as wrongfully detained. Basically, you're creating two classes of consular cases, and this might be ethically problematic for some, but I believe it's necessary. You have people who are legitimately arrested abroad for legitimate crimes or misdemeanours, and you have people who are unjustly arrested, a much smaller number, abroad from no fault of their own, perhaps to apply diplomatic leverage to the Australian government, or perhaps for some other, bad reason. And we need to distinguish between these two types of cases. Right now, we do not have such a mechanism. And the US has instituted a set of criteria for determining when somebody is wrongfully detained or not. And one of those criteria is whether the legal system of the detaining state is free and fair and has due process. So that's something that absolutely should be looked at. But it also gives the family members or the supporters or the lawyers of that detained person the opportunity to present evidence to, say, the Australian government to show that their loved one is innocent. And if that is proven beyond reasonable doubt to, the hostage envoy's office or whoever it is making this assessment, that person can be declared wrongfully detained. So I think it's a mistake to rely on some of these malign authoritarian regimes, court and judicial systems, to determine whether someone is innocent or guilty. We need to be performing that own, yes, subjective assessment ourselves behind the scenes in order to determine who gets those extra resources employed by the government to pry them free from such a situation.
Thank you. And just one more question for me now, and this really is in your capacity as representing A-WADA. Is it A-WADA's view that hostage diplomacy is a form of foreign interference?
Yes, it's pretty obvious that it is. We're seeing an increase in foreign interference and transnational repression throughout the Western world. Canada has an inquiry right now actually looking into this in a Canadian context. It's a very insidious grey area form of foreign interference, but it absolutely is, and it works, as Sarah Teich noted. Australia has paid a price. In my case, 3 convicted terrorists were released, not from Australia, but from a partner country in exchange for me. But there's also a diplomatic and soft power price that's paid every time we capitulate. And we're not sending any signal of disincentivization or any there are no attempts to punish these malign actors who are repeatedly targeting Australia. It is a form of foreign interference. And us not sending that signal that we're not going to stand for it and that we're going to pay that price again and again and essentially capitulate again and again, in my view, is actually encouraging it to happen further. And that might spill over into other forms of foreign interference too, more overt forms. Not tackling foreign interference broadly as a phenomenon, it probably will lead to more hostage taking as well as one tool in the toolkit of such malign actors' behaviour.
Thank you very much, Dr Moore-Gilbert. Deputy Chair, you have the call.
Thanks, Chair, and hi, Kylie. Thank you for making time today.
Thank you.
Look, I know I know what you mentioned earlier, so I don't want to repeat some of the questions or even your opening statement. But the one thing I do want to ask, since your return to Australia, have you seen any change, any improvement in how DFAT has conducted itself, in how it goes about dealing with cases like yours now in the future? Acknowledging that we've probably learnt a lot since situations related to you and others. But I just wanted to see if there were, from your perspective, has anything improved?
I would say some areas have improved, perhaps not in a very impactful fashion, but it at least shows that there is an awareness, particularly in the consular affairs section of DFAT, that criticisms have been voiced and that maybe some internal processes need to be changed. It's difficult for me to discern what's a cosmetic change and what's a more structural change, however. I think there have been efforts, particularly given some adverse media coverage, to demonstrate change, but perhaps this is more of a symbolic and cosmetic nature than an actual meaningful reform. That's my instinct, but given the lack of transparency around this issue, it's very difficult to tell. The only area that I would be able to point to definitively is a recognition that wrongful detainees, when brought home, need psychological treatment often, and that a DFAT psychologist has actually been made available for a very small number of sessions. We're talking up to 4 psychological sessions, which are obviously inadequate, but it's a step in the right direction, for A-WADA members, Sean Turnell and Chang, who've been brought home under the current government. That is a step in the right direction, as I said, but we need a more robust framework, and it's obviously not DFAT's role to provide psychological services. You know, that's not their job at all, and nor should they be in that business. But we need to have linkages to, and in A-WADA's submission, I recommended some torture NGOs that are present in all states of Australia that have specialised trauma-informed services that could be used for Australian wrongful detainees brought home. But we do need linkages and actual match-up to some of the service providers who are able to provide that other than DFAT. And I think DFAT has a role to play in linking people to those services. So, I mean, that would be
more coordinating roles, is what you're saying.
Yeah, like I guess a transfer of duty of care, you know, DFAT brings somebody home. But my experience was I was deposited into Australia and basically told, you're free now, go on your way, you know. Go find your own GP and you know, if I had physical health, I did have some physical health issues following my detention, then I can just go sort that out myself. Unfortunately, there's sometimes a need for real specialised care, particularly there has been former Australian detainees who have been physically tortured in prison and have injuries as a result of their physical mistreatment. Such people should never be told to just go off on their own and figure it out for themselves. So there's a real duty of care there when you bring someone home to ensure that they have that specialist mental health and medical treatment available. So I think there's a linkage and a connectivity issue there, and it would be relatively easy to solve if, you know, sort of agreements were drawn up with some of these specialised torture charities, for example, to provide that care, and DFAT would refer people to those.
I also do note that you're on a group, I think that DFAT and I think the Minister set up the External Advisors Group. I was hoping that you might be able to share some lights or detail a bit for the committee, for the purpose of the committee here. You know, when were you involved? What's been your involvement? Feedback that you provide? Are you able to share anything about the activities of that group with the committee today?
I would like to commend DFAT for the initiative in setting up this group. Unfortunately, the person who set the group up and her team have since moved on, and the issue of churn and staff turnover within DFAT's consular operations is a huge problem that I believe is highlighted in A-WADA's submission on a number of occasions. This is, you know, it's crucial that this diplomatic rotation issue is solved if a separate office or position is established by the government to look into wrongful detentions. So unfortunately, with the departure of the person who set this up, no further meetings have occurred. But I would also, and I don't want to be too critical here, but the view of myself and a number of other attendees whom I'm familiar with was that it was a wholly cosmetic exercise in sort of box ticking to try and demonstrate engagement without any actual meaningful engagement and without any transparency around what any advice given in this external group, how it would be actioned, if at all. The membership of the group was also extremely problematic. It was not wrongful detention. It wasn't focused on wrongful detentions. It was focused on complex cases, which is a catch-all phrase that can encompass anything from people stranded abroad or evacuated out of war zones, or orphaned children that are brought home, or all sorts of random issues that for whatever reason are kind of put in a too hard basket and are managed by complex cases. So there was a complete sort of, there was not a clearly defined purpose for this group, and the membership was not useful. It was not expert. It was not informed by, it was not, I think the membership of the group was problematic. I think there was no actionable outcomes resulting from any advice given. It's only met on 2 occasions, and I have not seen any change or positive result because of it. And I believe it's been frozen or disbanded since whoever the individual who instituted it has moved on. So I would not use this group as an example of any meaningful reform, change or outcome achieved by DFAT in this space.
I mean, have individuals or the department spoken to you directly about, and putting aside this group, but about any other feedback that improvements could be made and how we handle these situations going forward?
Myself and my A-WADA co-founders, Turnell and Chang met with senior DFAT representatives in March of this year, as we did with Minister Wong and her office. They took our feedback on board. We had a great discussion with them. There was an acknowledgement by, I'm going to get his position wrong, but he's a lovely guy called Craig McLaughlin, who's senior within DFAT, but I'm not 100% sure what his position title is. There was acknowledgement by him that perhaps a definition of a wrongful detention is necessary for DFAT to apply to cases that might be flagged with them as potentially being unjust detentions. So there was a recognition of that there, which we really appreciated, although I'm not sure if there's been any outcome or follow-up following that meeting. So the DFAT have been willing to engage with us at A-WADA, but again, you're having discussions, but you're not sure if any outcome has actually ensued following those discussions.
And I note that, and you probably want to say, we've discussed a bit about the US approach and maybe some other jurisdictions. Is where you're thinking what the US does is probably where Australia should head, like having a special envoy or someone that is the go-to person that can deal with these cases and provide the ongoing support once people return?
This is absolutely necessary. I cannot stress more strongly. I think our submission goes into the detail as to why this is necessary. As I said in my opening remarks, there are long-standing structural issues that have been going on since that were identified in the 1997 Senate inquiry into hostage takings and kidnappings, and the provision of consular assistance. So there are long-standing structural problems. One issue is that the buck does not stop with any one person. There is no one person that is explicitly responsible for managing these cases or identifying these cases. And so having a standalone office or role, in my view, it should not be located within DFAT, but I accept that most likely if it's instituted, it will be. But it's very crucial for this person to be long-term in the role, have expert understanding of the issues, so not just be someone rotated in from God knows where else, but someone with actual expertise and knowledge, particularly of authoritarian negotiations and, maybe the intelligence side of it as well. And for this person to be tasked explicitly with bringing our wrongfully detained Australians home. And, this is not currently under the complex cases purview. Complex cases in DFAT is there to provide consular assistance communication with families and other support, but they're not explicitly tasked with bringing Australians who are wrongfully detained home. And that's a shift in thinking, right, that the US has undertaken since 2014, following those ISIS beheadings of the US journalists and aid workers, which is what triggered this whole process in the US in the first place. They've gone through that period of soul searching and they've understood that, no, there needs to be an explicit directive on this new role or office that is established to bring our wrongfully detained Australians home, not just provide consular assistance. So, I think that shift is really needed. People fall between the cracks, and having the current ad hoc subjective approach, yes, it's flexible in a way, but it also allows people to pass the buck and follow their own narrow interest, which might at times not directly align with that of the detainee, which Geoffrey Robertson also highlighted.
Yeah. How do you balance, I guess, an approach of speaking out publicly, but also at the same time trying to have those diplomatic conversations, behind the scenes? And I think that's always been the biggest issue that probably every government will face. And I sort of pose that question to you. I'd be interested to see your take on that.
I have, I think, quite a nuanced take on the issue of media engagement. I appreciate the government's correct in arguing often that it can be counterproductive. It really depends on a case-by-case basis. But I would say that the kind of knee-jerk response of no media coverage whatsoever is not useful. I think you do need to, and if you had a separate office that is expert in this area, that's managing cases from beginning to end, communicating with families, providing a whole suite of different approaches, and it's all centralised within the one office, they will be best placed in that case to make a determination about media engagement. There are examples where media engagement, and I know you have Peter Grester there in the room who I hope will speak to this in his submission, because his case, I think, is an excellent example of where media engagement has actually helped free a detainee. My own, I would also cite, I think it's a bit less clear-cut than Peter's, but I personally believe, and it's impossible to demonstrate this, of course, objectively, that the media coverage of my own arrest, which happened 12 months following, it wasn't instant, really did help me. It protected me when I was in prison from the most egregious human rights abuses. It enabled me to get medical treatment and assistance, which had been denied to me prior. It helped reinstate those consular visits, which I mentioned were banned as a punishment for me for my misbehaviour in prison. And I do believe it ultimately propelled the political class in Australia, who are the ultimate decision makers, to take those difficult decisions to bring me home. So I think it played a significant role in the speed of my own release. It might not work in every case, though, and I think there's a danger in consular officials telling families not to go public as an automatic response, because if they do alienate that family, in the end, the family could sort of undermine the government's line, for example, in the media, if they are not working together with the government. It's much better to keep the family in the tent, work constructively with media engagement, make sure everyone's on the same page, singing from the same song sheet, and not putting out messaging that might undermine the government's negotiating position with that foreign state, whilst at the same time recognising that it could actually assist the government in negotiations, depending on a case-by-case basis. So I think a more nuanced response is needed, and having, again, a specialised office or role that's able to make that judgment based on actual expertise, prior knowledge, learnings from previous cases, I think that such a person would be best placed to make that determination.
All right, and just one last question before I hand back to the chair. I think whether we've discussed this in the past or you mentioned in your submission, I can't remember now, but in terms of people like yourselves and others who, when they do return, said countries that have held you will have put a note or have a recording of punishment, and therefore when you travel overseas in the future, you might be in a predicament where you might actually run into problems, especially if you're applying for visas or trying to travel overseas. What can we do as a country, as a government, to fix that? Is it having a legal note to make it clear that, if said person wants to travel to a country that they are offered some diplomatic us, acknowledging the circumstances of why you've had a punishment recorded against your name in another jurisdiction?
That's a fantastic question. And I know Kay Danes spoke at length in her testimony in the first hearing about this. For me, it's not the most pressing concern. I didn't even mention it in our recommendations because I feel that getting current wrongfully detained Australians out and fixing our system it should be the priority. But I certainly acknowledge that this is an issue, and I faced it myself. The US does, for example, provide a letter on SPIHA letterhead, which is often used for banks, financial institutions, mortgages, etc., saying the US government recognises this person as wrongfully detained. Please, during this period and that period, please accept this letter as evidence of that. And that is very useful for unfreezing bank accounts and these kinds of administrative issues. That letter could potentially also be useful when applying for foreign visas and travelling abroad. So I do think that it has a real practical impact, and it would be very easy for DFAT or the government to do that. And I know Hostage International has been advocating on this a lot as well, and they'll be giving evidence this afternoon too. Again, having a standalone office that specialises in this area, such a person would be best placed to also give advice. I know Sean Turnell, for example, has often faced this issue, and Peter Grester as well, as myself too, where if you're travelling to a country where you're not sure whether you'll be safe or not, you think you'll be fine, but there's a tiny chance you might not be. Who do you ask for advice on that? DFAT's often very reticent to say 100% yes or no, go there, don't go there, because obviously they don't want it to be on their head if something does happen to you. But there needs to be, again, a SPIHA-esque office in Australia for wrongful detention could be best placed to provide this advice. But there needs to be someone you can call or someone you can refer to say, hey, I'm going to transit through Dubai. I can't go to most of the Middle East because they consider me to be an Israeli agent or whatever BS that the Iranian regime charged me with, which is utterly ridiculous, but still endangers me if I travel to the Middle East, for example. Who can I clear this with? Can I transit in Dubai or Qatar or not, when I'm flying to Europe, for example? I don't want to get picked up again. And ultimately, it's in DFAT and the government's interest to provide that advice, because the danger of somebody getting rearrested is there, and that would be so much more of a headache for them if that did happen. And perhaps you can ask Sean about this because he encountered this with Vietnam on a number of occasions. So I do think having just a telephone number or the name of a person who's best placed within the government to provide that advice, or to provide a letterhead, official notice that can be used for foreign visa applications, it would be really useful. It's not the most important thing here in this inquiry by any means, but I do think every little thing helps, and it would be great personally, in my experience, to have such a letter.
Thanks, Chair. Thanks, Kylie.
Thank you very much, Senator Ciccone. Senator Steele-John, you have the call, noting that we are due to move on to our next witness about now. So if you can be expeditious with your questions, that would be appreciated.
Thank you very much, Chair, and thank you very much, Doctor. A lot of the questions that I had wanted to ask you, you've fully answered in your responses to other witnesses, to other senators, so thank you very much for that. I did just want to go, though, to one of your observations around the need for DFAT to have the capacity to not continually rotate its staff and individuals in relation to those cases. Could you go into a little bit more detail about the challenges that are created by that continual turnover, and also whether, in your experience, through your time in detention and also your kind of period after exiting, but continuing to engage with the department for whatever reason, whether there was a level of knowledge of actually what had been happening within Iran, or the structure of Iranian government, intelligence service, that was kind of commensurate with what you hoped you'd find, given those were the people leading the work to actually get you out of that situation.
Thanks so much, Senator Jordan. Those are two excellent questions. I'll try and be as brief as possible in my responses, mindful of time. Look, the turnover and churn is, fortunately perhaps, it's part of diplomatic work. I accept that it's in every Western country that they manage their diplomatic corps in such a fashion, and there is a place for it, of course. But when it comes to wrongful detentions and hostage takings, having that in-depth experience, institutional knowledge, learning from previous cases, it's really, really important. You don't want to have to reinvent the wheel every time you get a new case. So there's that aspect, that knowledge retention and experience, which is developed over years working in this space, is incomparable. If you have someone coming in, and I note that we've, I think, had 3 or 4 different heads of the complex case unit of DFAT in the last 12 months. So, you know, that's the rotation and the churn of DFAT staff in this space is concerning to me, but it's also traumatizing for families of current cases because they have to tell that story from scratch all over again every time a new staffer or a new case officer or a new head of complex cases comes into the picture. That person does not appear actually usually to be across their previous counterparts' work. Maybe the approach shifts and changes also with each new person coming into the role. So it's very frustrating and re-traumatizing actually for family members and current cases to have to deal with a whole raft of different people churning through the system constantly. Some of these people have no training or expertise in trauma-informed communication. I would say the vast majority of them have no expertise in wrongful detentions or hostage takings whatsoever. So they don't actually have any in-depth knowledge of the issue at all. They might have consular experience, but this is a very specialised area. And that's not a criticism of them. I mean, there's some fantastic people in DFAT who are doing a wonderful job, and they do deeply care about, what they call their clients, which Geoffrey Robertson also critiqued. But at the end of the day, this is a very specialised field that traverses, as Claire Chandler was saying, issues of transnational repression and foreign interference. So it's a broader geopolitical issue than just consular. And we need real expertise in this area that is long-standing in this field and not on diplomatic rotation. When it comes to whether the staffers involved have any in-depth knowledge of the cases or the countries in which these cases are occurring. Sometimes you have people who have worked in the embassies of those countries. I had engagement with 2 Australian ambassadors to Iran during my incarceration, and I found both of them to have robust knowledge of the Iranian regime that was very useful, including of the IRGC, my captors, when I was there in the country. So I think the in-country expertise is greater than the expertise in DFAT's Canberra operations. I think that there is a real need for external experts to provide information to DFAT on some of these cases because we do not have that country-level depth of knowledge in the consular service that perhaps is required. But again, if we instituted a standalone role or office to manage such cases, that person could potentially consult with external experts or other diplomats who might not be in consular right now but might have had prior experience with other cases. So it's pulling knowledge from various parts of the system together into one office and having one person responsible for that I think is key. But yeah, again, there are great people doing great work, but I don't think that depth of expertise is necessarily there, nor that retention of institutional knowledge each time someone churns through the system.
Okay, thank you very much, Doctor. I appreciate your evidence today, and I'll hand back to the Chair. In the interests of time, however, continue to look forward to engaging with you and the organisation in the months and probably years to come.
Thanks so much, Senator Steele-John. We really appreciate your engagement and that of all of the senators involved in this inquiry. It's been fantastic.
Thank you very much, Senator Steele-John, and thank you, Dr Moore-Gilbert, for appearing today. The committee would appreciate that responses to questions on notice be provided by Friday, the 1st of November 2024. And that's all we have for you today, but we do note that we have a few more witnesses from A-WADA appearing throughout the day. I'd ask that you now disconnect from the video conference, but of course if you wish to continue listening, you can do so on the Australian Parliament website. And I now welcome our next witness, Professor Sean Turnell. Professor Turnell, I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, would you please state your full name and the capacity in which you appear today?
Yes, so my name is Sean Turnell. The capacity in which I appear is pretty much under my own volition, as well as I am a member of A-WADA that Kylie so movingly and wonderfully spoke of in the last hearing.
Thank you very much, Professor Turnell. I now invite you to make a short opening statement, and at the conclusion of any remarks, I'll invite members of the committee to ask questions.
Yeah, thank you so much, Senator Chandler, and thank you to the whole team, the whole Senate committee there. As I was going to say at the end, actually, this whole process, I think, underlines some of the virtues of our system that hopefully I will celebrate in this testimony. So my name is Sean Turnell. I was held as a prisoner in Myanmar from February 2021 through to November 2022. What made my situation a little bit odd, I suppose, is that I was actually working under contract to the Myanmar government on behalf of with the support, rather, of the Department of Foreign Affairs and Trade in Australia. But of course, my situation then became deeply problematic following the coup in Myanmar on the 1st of February 2021, and I was detained from that moment on and ultimately charged and convicted of breaching Myanmar's Official Secrets Act. Basically, I was charged with being a spy for Australia and various other entities. I think that there are certain odd issues to do with my case that I think have great relevance elsewhere, which is actually Australians operating in countries around the world in which what is an official secret act or not is now really starting to spread and becoming deeply problematic. So I think that's probably a different issue than what the committee here is to decide. But anyway, just to highlight that this is a growing problem. First up, it's important for me to put on the record that I'm the incredibly grateful recipient of Australia's efforts to secure my release from Myanmar. These are the efforts of countless Australians, of government, of the Department of Foreign Affairs and Trade, and of numerous politicians, many of which are in this room right now, but also including the Foreign Minister Penny Wong and the opposition Foreign Affairs spokesman Simon Birmingham. So there's a number of people. It was very much non-partisan and a real unifying moment, dare I say, if there was that virtue all got out of my detention. I also saw during the whole time I was detained of the power of that declared care in Myanmar, both in terms of my fellow prisoners, but also, funnily enough, of the people who were detaining me, who were effectively my hostage takers. And there was one line that used to get said to me over and over, which was along the lines of, Sean, you're going to be okay because you come from a powerful country. And that really struck me at the time because I didn't know what they meant. At first I thought, well, hang on, Australia doesn't have a big military. We're a big economy, but we're not that big. But what, of course, they meant was something different. What they meant was that I came from a country that cared about its citizens, that I came from a country whose government was compelled and held accountable by its citizens to bring other citizens home when they were wrongfully detained abroad. And this is in great contrast, of course, to countries like Myanmar, where the government is nothing but a threat. You don't look to the government basically for anything. The only thing you ask of that government is essentially that it leaves you alone. And it really struck me, actually, at that moment, that this was an extraordinary soft power that Australia and like-minded countries have. The appreciation that Burmese people had of that power that Australians possess because they came from a country that would essentially look after them was an extraordinary thing. And so I guess for the purpose of this committee, the reason why I just thought I'd mention that is I suppose in many ways we're looking here at a problem that needs to be fixed, but to just employ that dreadful cliche about a problem being also an opportunity, perhaps this is, because, through the formal devices of the sort that Kylie has just been talking about and other people have been talking about, we also do have an opportunity, in a sense, to put some foundations under that soft power. Australia is a country that cares, and that sends a very powerful message, I think, to all sorts of people overseas, from prospective students to migrants to, I guess just Australia's standing in the world. So anyway, I just thought I'd mention that from the outset. But of course, there's a bit of a flip side to this, and that is that other countries, bad actor countries who are in the business of hostage taking, also see that as a vulnerability. In other words, they see it as an opportunity to yield leverage over the country of hostages that are taken. So one has to recognise that, and also that this whole notion of hostage taking is on an upward trajectory around the world. It would seem that it's only going to get worse, and of course it's going to get even more worse for the people who are actually caught up in it. So we've got a problem. And it seems to me the essential problem to state it is, how do we disincentivise this sort of hostage diplomacy? How do we reduce the dividends that bad actor countries feel that they can get from it? And then, as a secondary question, but no less important, when hostages are taken, how do we care for them, and how do we care for their friends and families back home here in Australia? So that seems to be, I guess, the essential problem is, on the one hand, disincentivising hostage taking, and then secondly, how do you care for hostages and their families and loved ones if and when they are taken? Now, I want to then just turn briefly to some possible actions that I want to suggest. These two are just in my own words, but they're very, very consistent. In fact, they're 100% consistent with the submission of A-WADA. And there are many other, of course, recommendations of A-WADA, which I probably won't talk about in my initial opening, but which one can rightly assume I'm advocating as well. Okay, so the first of my recommendations would be, and I'm just building on what many people have said to the committee already, the creation of a standalone role for an eminent individual and supporting office devoted wholly to the task of helping hostages and their families, potentially, presumably, free from, or preferably rather, free from other responsibilities. Again, as already mentioned ad infinitum, in the USA, we've got something similar created to that by this Office of the Special Presidential Envoy for Hostage Affairs, or SPEHA, as I'm sure we're all familiar with already. And then, of course, we've got the example in Canada via that new law that imposes sanctions and other restrictive measures against hostage takers, all with that task of trying to raise the stakes, reduce the incentives for wrongful detention. And so just to add my voice to calling for Australia to perhaps come up with similar legislation, some sort of perhaps Hostage Takers Accountability Act of our very own. Whatever the institutional form, this standalone person and the office connected to them would have its core an understanding, I would hope, of the sovereignty of the hostage, of the individual who is being detained, in determining all sorts of actions on their behalf, including the issue, and I noted the conversation about this earlier, about the public disclosure of their case, but we might talk about that later. The role should be, and again, as noted by previous speakers, be held by an individual of senior rank who is not subject to the rotation that normally happens within the diplomatic service. The position obviously should report to the highest levels, the Foreign Minister, the Prime Minister, etc. And that person should act as Australia's representative in all aspects of hostage taking, not only in terms of actual negotiations with hostage taking countries, but in broader efforts to try and create an international framework. The second thing I just wanted to state about in my talk about my opening statement, is that I think this office, this individual, should have far-ranging responsibilities and powers beyond simply the period of detention. And again, I'm touching upon some of the things that people said already. For instance, in assisting hostages when they return home, and in following up on hostage episodes such that they are simply not filed away. For example, in determining hostage-taking individuals who might be subject to Magnitsky-type sanctions of the sort Australia already has on its books. Now, in my case, I've had, and I think Kylie alluded to this, I've had the experience where the Myanmar regime that took me has in many, many ways sought to reach out and continue to punish me, if you like. After I got back to Australia and recounted my experiences in the media, the regime in Myanmar withdrew the amnesty that they had given me, reimposed the sentence and threatened to have me arrested through Interpol or various other measures. I've also had the perhaps even more bizarre experience of business entities connected to that military regime seek redress in London courts for libel against various things that I've said in the media and in books and so on. Those actions are more about silencing, I hasten to add, rather than seek damages. But it's a very real issue and a very frightening thing when you get a letter in the mail from one of the Golden Circle London law firms saying that they'd like to take you to court for things that you've said. I guess the other, at a more positive level, so, potentially punishing hostage-taking individuals at a more positive level, some system of rewarding people who help Australians who are taken as hostages. In my experience, this is something I feel very strongly about. I had a great many Burmese people who put themselves at incredible risk in supporting me. Many of those individuals were punished for that very action, many of them forced to flee Myanmar, many of them currently refugees in Thailand and other places, and many of whom would just be ideal recipients for protection visas and the like. So having something in place that might reward people for that to be known, that help Australians in these terrible situations might not be a bad thing. Now, I have some other items that really just draw directly from A-WADA's submissions, but in watching the testimonies today, I've noted that probably a lot of the meat comes out in the question time, so I might just stop there rather than just list through some of the other items, which, as I say, are part of the A-WADA submission in any case, and perhaps elaborate on anything you would like me to.
Thank you very much, Professor Turnell. I'll start off with questions now. First of all, at a personal level, how important is it for Australians who are wrongfully detained and their families, both during and after their period of detention, that mistruths about the reasons for their detention that might be spread by the regime or the government detaining them don't become the accepted rationale here in Australia?
It's immensely important, Senator Chandler. One of the things that kept me going through the whole process was the notion that my case was so absurdly unjust that it would be apparent to everyone why I was there and why it was unjust, and there were no value judgments being laid against me. But at the same time, I always had a worry at the back of my mind that the regime would try something, that they would find narcotics in my cell or something, or some other charges would be brought. And so I think having certification, if you like, from my own government that there was nothing that I'd done wrong was incredibly important. So, yeah, I think that's a very significant element of just holding things together, actually, when you're a prisoner.
Do you feel that the support and the information that is provided to families by the Australian government while their loved ones are detained overseas is adequate, and what more should the government be doing to keep families informed and make sure they are supported in these circumstances?
So I think the information flow was inadequate in my case, but to be fair to DFAT and the others involved in the process, part of that was simply that the Myanmar authorities refused to give that information. So I think in my case it was much less of a problem of information communication flowing on from DFAT than it was information and communication coming from the regime, all of which just goes to underline the point that in countries like Myanmar, Vienna Conventions and all the rest of it are just abandoned. I heard Kylie mention that, she had no contact and in other cases over and over again. There was no contact allowed during interrogation periods, and that was certainly the case with me as well. So some real serious problems of communication. One of the things in the broader A-WADA submission we spoke about was much greater support in terms of communication to the families. And so obviously if there was a problem with communication from DFAT back to the families, the mechanisms that we're recommending are about addressing that.
Thank you, Professor Turnell. I want to ask you the same question that I asked Dr. Moore-Gilbert earlier, and that is, what can Australia do to deny regimes the tactical advantage that they seek in sort of publicly pretending that the detention of Australian citizens is for some sort of legitimate reason, while behind the scenes we know they're sending the message that they're effectively trying to leverage our government in some way?
Yeah, so I think some sort of straight-up process of stating that the case is unjust. And I think what would be critical here, and again, many other people have testified in this way, of properly identifying people who are unjustly or wrongfully detained from normal criminal cases. And on the face of it, it seemed like a less important issue, but for all the reasons that you've mentioned, it's absolutely a critical thing of having such a definition and for the government to be clear about that. And we know that the Americans have done it, and it seems to me that there's no reason why Australia can't do it either.
Thank you very much, Professor Turnell. I might hand the call to the Deputy Chair, Senator Ciccone.
Thanks a lot, Claire, and hello, Sean. Thanks for your time today for the committee. And you may have heard some of the other questions I asked Kylie earlier on. I'll probably put them to you as well. But in terms of your experience now, being back and what have you felt has changed? Have you seen any improvements about how governments have now gone about dealing with situations like yourself and Kylie and others have gone through?
Yeah, it's an interesting question, eh? I was actually the grateful recipient of some changes that followed in the wake of Kylie's experience. So, and I'm sort of hoping that gradient might continue, if you like, and that the people that follow me, and of course we know there are cases that might be improving, although I think we're getting suggestions through this hearing that may not be the case. But yeah, so my overall experience, I think, was better than Kylie's experience, but I think it was because Kylie had to go through all of those things. So, and probably as is well known, one of the things I celebrated in my story was that I was the recipient of Kylie's book while I was in the prison. So I was able to take personal advantage of that story and able to be better interact myself, actually, in my own case. So I'm hopeful things are improving, but I think that all also gets us back to the issue of needing some proper process rather than sort of the arbitrariness of much of what we're talking about. Because I'm very conscious of many of the very positive experiences that I had were the product of individuals in DFAT and elsewhere who were just great people, and were not necessarily acting in ways that were part of a sort of standard operating procedure, but they were just operating out of their own goodness of heart and all the rest of it. So I guess what we need to do is try to come up with some system that can bring that straight away without, and automatically without relying on people's goodwill.
Yeah, and I guess on that, so do you see then acknowledging all the goodwill and the great work that our people in DFAT do, that are you someone who shares the view that we might need to look at how we change how we conduct ourselves, or whether we need a special envoy, or having what we have now today but making adjustments within DFAT about how we tackle these issues going forward?
Most certainly, Senator. Obviously, we need to keep the spirit of the way we go about things. And I mentioned, what I think is the real soft power of the care that we have towards our citizens abroad. But yeah, I don't think this should be hostage to the arbitrary aspect of it that I've mentioned. So I'm very much supportive of having someone like a special envoy. Funnily enough, I think that would actually make it easier for a government, just as I think the automatic triggers in things like the Canadian legislation make it easier for a government. Because I think if you have automatic processes and you have individuals and entities devoted specifically to assisting a hostage and dealing with a hostage situation, I think you actually clear up space for the foreign minister and for others who might have to deal with other issues, and I think it actually expands the negotiating strength of Australia to hostage-taking countries when there are these sort of elements where, perhaps the foreign minister can point to, well, look, the taking of this person unjustly has automatically triggered this amount of sanctions. And it actually gives, I think, a little bit more room for manoeuvre for the more standard foreign policy actions we might be undertaking.
And because I do note that you do advocate for that special envoy office. Do you see there'd be any risks in if you have just an envoy and not the usual ministerial government-to-government relations, or do you feel like that having this special envoy role would actually, provide greater the ability of governments of the day to be able to negotiate with countries like, one that you were obviously had to deal with, or others in the Middle East or other parts of the country or of the world? Like, do you see that there could be any risks or downsides with having a special envoy as opposed to what the Australian context, what we have with the ministerial and DFAT arrangements at a government-to-government level?
Yeah, no, I don't. I actually see those risks as actually being reduced. And to use my case as an example, for reasons that I appreciate, personally, at very great level, I think Australian foreign policy was hostage to my status as hostage towards Myanmar. So in other words, my situation basically captured the entire conversation about Myanmar. But I think that the sort of thing we're talking about at the moment would allocate that to another powerful individual, leaving other actions potentially to be taken by government with respect to the broader relationship. But at the same time, having very high profile policy focus on the hostage. So yeah, to me, I think it de-risks actually elements of broader foreign policy.
Am I right in saying that you're involved in other groups within DFAT, like Kylie, or not? Have I got that mixed?
Well, I am.
Are you part of any committees?
Yeah, I'm on an advisory committee, Senator, whose name just escapes me at the moment.
Is that the external advisory group?
It is. It is.
Well, yeah. Okay.
It only fairly irregularly meets, but yeah, I'm a part of that. But beyond that, I don't have any other role with DFAT.
Have you felt that's been a good opportunity for people like yourself and others to be able to share experiences about how we handle these situations going forward?
It's so irregular that I'm not sure about that, mate.
How often does it meet, or how often has it met?
It was a long time ago. I'm just trying to think. I want to say about a year ago, but it was quite some time since it's met.
Right. Okay. Well, that's also good to know. Okay. In terms of then, I guess the more broader picture, as I said to Kylie earlier on, I mean, do you see where if governments have to balance and have a balanced approach about speaking out publicly versus the more diplomatic channels? Do you acknowledge that there are some risks involved if people and families, for that matter, do speak out without sort of having a coordinated approach with government around, well, how do we best get the person home? Because ultimately, we want to get our Australian citizens home and home safely.
Yeah, so I think on this issue, it is very much case by case. I would, my own feelings weigh towards greater exposure and greater publicity. And certainly in my case, I think the publicity surrounding my detention greatly assisted me, and also assisted me very directly in the way that Kylie appreciated as well, which is that actually I think it protected me, funnily enough, just against abuse. I think the idea that you're very much under the focus of the media from your home country and so on makes the hostage-taking authorities a little bit more reticent, I think, in mistreating you, and even how you might appear on television and so on. So I think in that really very basic way, it has an impact. So, yeah, so my default would be towards that. I am aware, of course, of situations where that may not be the case, but I suspect those considerations would be in the early process before people are charged and enter into, some judicial process of whatever validity. Once that happens, it seems to me, and once the whole situation has become entrenched, I think the media spotlight is greatly to be welcomed, I would think, in most cases. But yeah, I would imagine in very early days, in some cases, a quiet approach might be better. But yeah, in general, I think letting the sunlight in is not a bad option.
Oh, good. And just lastly, I just want to know what type of support you've received, if any, after your detention. There's been a discussion with some other witnesses today and our last hearing.
Yeah, so again, I think this area is a really good example of where I was the beneficiary of the very poor experience that Kylie had. So I had immediately upon my return assistance with respect to health and a brief period with a psychologist and so on. I think there's more that can be done on that. I think the idea of having full and very formal debriefings, I think, would be something that would be beneficial. So I suspect, again, I'm on a gradient, hopefully leading to something better. But again, a lot of this, I think we would envisage coming out of this special office, which, and as I mentioned in my comments earlier, wouldn't just be focused upon the period in which a hostage is taken, but very much after that period as well.
Well, I guess that's a good point. Maybe even ongoing engagement with the said country to make sure if future situations occur again, there's at least some relationship there. But look, anyway, thank you very much for your time today, and thank you for making time with the committee. And
thank you, Senator.
You're doing okay, so thank you.
Thank you.
Thanks for making time. Thank you, Chair.
Excellent.
Thank you very much, Senator Ciccone. Senator Steele-John, you have the call.
Thanks very much for your evidence and your time with us today, Professor Turnell. I want to go to a similar theme that was picked up by the previous witness first, and that is your experience once you had been released and returned to Australia in terms of the supports provided to you by the Australian government. I particularly would really appreciate your perspectives on the psychological supports you were or weren't provided with, and the ways in which they might be able to be improved, but also any efforts that you were part of by the Australian government to solicit from you any useful information that you had gained about the state of play in Myanmar at the moment, or any other useful information that you might have been able to provide.
Thank you, Senator, for that question and your ongoing support, of course, mate. Taking the issues in turn, in terms of psychological assistance, I was given 4 sessions with a psychologist after my return, which took place, I think, around a month after my return and ran for about those 4 meetings across a couple of months. They were very useful. I think they could have continued. I think extending them might not be a bad idea. The other area for extending them, I think, is that those sessions were just for me and were not for family members. And I think, as we all know, family members and loved ones in this process sometimes suffer, I think, more than the hostage, actually, because at least in my case anyway, that the hostage knows pretty much what's happening to them all the time. And of course, for loved ones, they've only got to imagine. And sometimes those imaginings can be quite awful. And then, just the whole process of reintegrating and so on. I think it would be good actually to have sessions with psychologists, just opening things up and perhaps laying the groundwork of things that people will experience, and just, I think, preparing people for what's sometimes a difficult readjustment. So that's on that. On the soliciting information, it's a really good question. In my situation, much of that was informal with people who were involved in my case, but those people, of course, were involved in Myanmar anyway. So there was quite a bit of information solicited from me in that way. But I do stress it was informal rather than any sort of process through which I could go and identify things. So, for instance, I think I would have liked the opportunity to identify some of the perpetrators. And to perhaps have briefed people a little bit about that. So I think, as with the other issue, and in fact all the issues, I think it's just a matter of sort of institutionalising some of this stuff, again, rather than sort of just relying on individual nous, if you like, of officers who might be involved.
And can I ask you, in terms of those 4 sessions that you were offered, was that in the form of a rebate or payment to the value of 4 sessions, or was it with a particular individual? And if it was with an individual, was that person particularly trained in working with somebody who had been subject to wrongful detention?
So in my case, the person was trained and skilled in trauma, but not directly in hostage taking or things like that. But they were a specialist in trauma, and that person was arranged by DFAT and selected by DFAT.
And were you given any indication as to why the number of sessions were capped at 4? It just seems to be a slightly arbitrary number. Why not 3? Why not 5?
Yeah, Senator, it's a great question. The number seemed arbitrary to me too. I don't know whether it was meaningful. Certainly, I felt better after the 4 sessions. I don't know how that number was arrived at.
Okay, thank you. I mean, it does strike me that the better access scheme that's available to everybody at least affords you 6 and then 4 if you have a chat with your GP and access that plan. Can I ask you, I know you haven't given us a formal submission, but you are part of A-WADA, and one of their recommendations is for the establishment of redress pathways that would be able to be accessed by individuals in terms of seeking further redress from countries that have engaged in wrongful detention. Now, acknowledging the limits of the Australian government's ability to compel, pardon me, I've got a little bit of a frog in my throat at this end, but acknowledging the limits of the Australian government in compelling a nation to engage in such a process, do you have any thoughts on what a redress avenue could look like, or the efforts the Australian government could make to establish those pathways?
Well, certainly I think those pathways would be immensely useful in that de-incentivising process that I mentioned earlier, just lifting the bar, lifting the costs for hostage-taking countries, in which, as I mentioned, if there is no follow-up, then it really doesn't matter whether we've got Magnitsky Acts or anything else on the books. So some sort of follow-up in the manner of redress, I think, would be extremely useful at that end. Likewise, Senator, my particular example where, if anything, I've experienced the opposite, of course, where my detainees have actually used the legal system internationally to come after me. So, you know, it's quite extraordinary, and the distress that causes has been really palpable to me, and the ability to push back, you know, through in a sense, the same sort of avenues would be really useful, I think.
Yes, I mean, it occurs to me that there are mechanisms that exist for governments, corporate entities, financial institutions to seek redress if rights under international law or trade agreements are violated. It would seem to me sensible that we would at least explore mechanisms to enable that to occur. Similarly, you've been quite critical, Mr. Turnell, of the Australian government's hesitation to place Magnitsky-style sanctions upon the junta during the period that you were imprisoned. What's your view as to why the government failed to take those actions for that period of time?
I think there was a couple of reasons. One of them related to me personally, and then secondly, I think the broader political situation. So on the personal aspect, and you know, again, just with my hat on as a human being, I think it was partly to protect me, to in a sense send a signal to the regime: look, we care about getting Sean home. Please do this, and if you do that, then maybe some sanctions are not going to come your way. So yeah, so as I say, I appreciate that as an individual, but with a sort of my political hat on and concern for Myanmar, it worried me. It's worried me since, but it worried me at the time. I remember people in the prison, other Burmese prisoners, coming up and saying, "Oh, Sean, Australia is lagging a little bit on the sanction side, and we think it's because of you." And of course, that didn't make me feel very good at all at the time to be used as an excuse by the regime in that way. So that was one aspect. I think the second aspect, though, is sort of probably a little bit outside of what we're talking about today, but just Australia's broader foreign policy. I think we took the idea that that this was the whole Myanmar story was best dealt with through ASEAN. And Australia, of course, is very concerned to build up ASEAN and to make it a viable entity, etc. So I think we were concerned, in a sense, to follow the 5 points that ASEAN had put out on Myanmar. So I think that there was that aspect to it as well.
And can I ask you, in terms of your personal view, you had people coming up to you saying, "Oh, you know, we're lagging. Australia's lagging, and it's potentially because of you." I also had a number of conversations during the time of your imprisonment where it was put to me that sanctions couldn't be applied for potential fear of what would happen to you. That's one of those cases where a lot of people were talking about you and assuming what you would or wouldn't want. But in retrospect, how would you have liked to have seen the Australian government implement sanctions or address the question of sanctions during your period of imprisonment?
Yeah, so I think, Senator, this gets to the issue of what I see as a virtue of having automatically triggered sanctions and other mechanisms against hostage takers, because I think that does allow a degree of flexibility, and it does allow a certain separation of actions that the government can undertake. Now, of course, all of this is still dependent on the hostage-taking government and how it receives the message on that. So there's a bit of a communications challenge there. But it does seem to me that the setting up of a SPIHA-like entity and things like automatic sanctions that are triggered by hostage-taking actually gives it a bit more of the flexibility there on that foreign policy end. You know, again, I don't want to underplay the challenges, because you've still got a recipient in the hostage-taking government regime that, you know, may choose not to receive the message, but nonetheless, I think it gives the hostage person's government greater room for manoeuvre.
And just finally, Professor Turnell, just two questions of quick clarification. We've got in the US the Levinson Act. We've got the Canadian government, the Parliament considering the Hostage Taking Accountability Act. I would imagine that, in your view, it would be beneficial for Australia to look to both of those pieces of legislation and draft an Australian equivalent.
Most certainly, yep.
Excellent. And just finally, in terms of those services and supports provided to family members whose family members are subject to wrongful and arbitrary detention, would it be your recommendation that the Australian government should extend access to psychological supports and also potentially financial and income supports to those family members while the individual concerned is subject to wrongful detention? The reason I ask is because if an Australian family was subject to a natural disaster, for example, in a fire zone or a flood region, they'd be eligible for certain economic and financial payments from the federal government. It's always struck me as odd that if your family member is wrongfully detained by a foreign government and they may be the primary income provider to the family, there isn't actually an automatic recourse to financial support that I've been able to identify. And also, similarly, if you were the family member of a serving military veteran or deployed personnel member, you'd be entitled to psychological support to enable the family or partner to process that experience. And yet, in this case, neither of those supports automatically seem to apply.
I think, Senator, that is an incredibly important point. I think the pressures, the tensions on the family are way underestimated across the board, and the whole process of readjusting, etc., of all the individuals who are traumatised. And so some sort of support at the psychological level, I think, was definitely called for. But I'm very pleased that you highlighted the financial aspect to it as well, because, of course, there's nothing that puts families under greater pressure than, I think, financial considerations. And so if that's added on the top, it can really be a toxic mix. And I mean, even in my own situation, I mean, I'm, relatively okay, but I haven't been able to find any employment since coming back 2 years ago. And, I'm in an immensely privileged position in so many ways. And so I would imagine for others it must be extraordinarily difficult, and even being in the position of being able to seek employment would take some time, but there is no support for that.
Okay, thank you. Thank you, Professor, and thank you for your continued advocacy on this issue and your work to highlight human rights abuses in Myanmar, and continue to place pressure on the government to do more. It's very much appreciated.
Thanks so much, sir.
Thank you very much, Senator Steele-John, and thank you, Professor Turnell, for appearing here today. The committee would appreciate that responses to questions on notice be provided by Friday, the 1st of November 2024. And I ask that you now disconnect from the video conference and you can continue to observe the hearing on the APH website.
Thank you.
Thank you. And I now welcome our next witness up. I now welcome Professor Peter Grester. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full name and the capacity in which you appear today?
Thank you very much, Senator. My name is Professor Peter Grester. I'm also a member of A-WADA, but I am appearing in a personal capacity today.
Thank you very much, Professor Grester. I'll now invite you to make a short opening statement, and at the conclusion of your remarks, I'll invite members of the committee to ask you questions.
Senator, thank you very much for the opportunity to address this committee personally about a subject that, for obvious reasons, I feel quite strongly about. I'd like to make a few additional remarks to complement my submission, and I do thank you for the opportunity again. While the number of Australians detained abroad is thankfully a relatively small and exclusive club, the issue, of course, has an outside impact, and I'm not merely referring to the impact on those family members, the individuals who've been detained. If it was just simply a question of managing those complex consular cases, it probably wouldn't justify a Senate inquiry on its own, but this clearly is a much bigger issue, and as we've been hearing through the submissions earlier today, it does have much larger and more significant foreign policy issues. Governments don't simply arrest and lock up foreign nationals for the sake of it. They do so with particular political and diplomatic ends in mind. And so the way our government handles these cases is inevitably going to have broader implications for Australia's relations with those states, along with any others who are directly or indirectly involved. Now, as my submission and others have made clear, we do recognise that every case is unique. I'm certainly not recommending a one-size-fits-all approach. But I, and as we've just been hearing some of my colleagues who've been through similar experiences will attest, we all believe that a set of more coherent, coordinated and consistent strategies could help resolve those cases far faster and support the detainees and their families far more effectively than at present. Now, as I mentioned in my submission, and I am a member of A-WADA, and I fully endorse their submission, and I know you've heard from my fellow members, so I don't want to waste your time right now by duplicating A-WADA's points. But there are a few things that I do want to emphasise before the committee today. Anybody arbitrarily and unjustly detained is only ever going to be released under one of two circumstances. Either the offending state achieves their aims when Australia bends to their will, or the cost of continuing to hold a detainee becomes higher than their value as a hostage. I believe there's great value by working with like-minded states to defray and limit the impact of arbitrary detentions. Now, the Canadian government, as you're well aware, has taken the lead with its 2021 declaration against arbitrary detention in state-to-state relations. This is a multilateral project that has collected a group of countries behind the declaration, and while the statement itself is relatively bland, I believe it could form the basis of a coalition of countries who agree to support one another whenever any member state's nationals are arbitrarily detained. If all agree to a relatively painless set of actions, such as against the offending state, such as visa restrictions, Magnitsky-scale sanctions, statements of public condemnation, and raising the issue in meetings and international forums, and a host of other diplomatic levers, collectively it would raise the cost of continuing to hold someone and limit their offending state's ability to extract concessions from a detainee's home country. The existence of that kind of coalition would also act as a powerful deterrent to future detentions. The second point I'd like to make is the lingering impact of hostage diplomacy on detainees long after they've been released, and we've just been hearing about that from my colleagues. I know from what I acknowledge what Kylie said in her submission, that the impact on travel, for example, of ourselves and my colleagues is a relatively small issue, but it does, I think, have larger symbolic consequences. Now, it's been almost a decade since I walked out of my prison in Egypt, in a case that was universally recognised as utterly unjust. Yet late last year, New Zealand tried to kick me off a flight from New York to Sydney that was transiting Auckland, simply because I'd declared previously my conviction in Cairo. I've had to go through sometimes egregious visa processes at times to get into the United States, including periods when I've been speaking at the United Nations, the White House and the State Departments. I and all those who've been detained and convicted of sometimes very serious criminal charges, such as Kylie and Sean and Chang, have all had similar problems. Of course, as I said, these are personal irritants, but they also constitute a form of continued persecution, even though there's no rational or reasonable person would ever treat us as convicted felons, spies or terrorists. They also serve to validate the original charges, and I think this is the key point. We can never lie about what happened to us on official forms, but I would like the committee to consider ways of helping us invalidate those criminal records when it comes to official processes such as foreign travel. And I think if there is a theme that I would like to reflect here, that a lot of the recommendations are in some level, and a lot of the issues that have been discussed are in some level relatively minor, but a lot of this is about sending very clear messages that the Australian government does not countenance, will not accept, will not acknowledge arbitrary detentions in a lot of in these cases. Finally, I would like to congratulate the committee for considering this issue in your inquiry. I realise a lot of people will regard this as a relatively fringe issue, but as we've been hearing, it does have outsized consequences, as I said, for the individuals concerned, but also for Australia and the government. Thank you.
Thank you very much, Professor Grestron. On that last point, I think the concern is that we are seeing this sort of behaviour from foreign regimes occur more and more frequently, and as evidenced by the fact that we have a number of recent former detainees appearing at the committee today, we know that those numbers are only increasing. And so I guess I'm interested in your thoughts about how important it is for Australia to have a robust framework in order to, recognising that it is happening more often and I guess put the minds of those that might be impacted by this at peace, but as much as they can ever be put at peace, but more broadly having that framework to actually act as a deterrent to those regimes that are engaging in this behaviour.
Look, I think that deterrent is crucially important. I think it's indisputable that as unpleasant as it is to acknowledge it, we seem to be heading in the direction of travel internationally is towards a more hostile and divided world at the moment. And those are circumstances when the potential for hostage diplomacy is likely to come up, and we're likely to see more people detained arbitrarily. And so I think a clear framework, a clear policy framework, a clear envoy, as has been discussed, are all really important parts of not just of strategies, not just for dealing with detentions as and when they come up, but as a very clear message to states, to foreign states that might be contemplating detaining an Australian, that we have a robust strategy in mind. And I am convinced that I guess if there is a message for me, it is the value of a coordinated response, a coordinated multilateral response as a part of that overall strategy. In my case, I'm convinced that the reason I'm here today and not still in Egypt is because, more by accident than design, a large number of foreign governments were engaged in our detention. I'm half Latvian, so the Latvians engaged the European Union. I worked for the for the BBC previously, and some of the people that were co-accused in our case, even though they weren't arrested, were also British nationals. My colleague Mohammed Fahmy was also half Canadian, so the Canadian government got involved. Both Mohammed Fahmy and myself had also worked for US news outlets, and so the White House and the State Department got involved, and that made it, by definition, a multilateral problem for the Egyptians. That reduced the impact on any one government. No government had to carry the complete can. No government was necessarily involved specifically in bilateral negotiations. It became a very complex multilateral problem for the Egyptians. And I am convinced that is why I'm here today. I think a coordinated multilateral approach would act as a powerful deterrent, but also act as a powerful force for resolving these cases quickly and judiciously and with a minimum of cost to Australia.
And I'm not sure whether this was the case when you were detained, but certainly today we've heard from a number of witnesses who've all pointed out that Australia is not, does not have as mature a model for DFAT to deal with wrongful detention cases in comparison to some of our like-minded. So talking about that need for a multilateral response, do you see the ability of Australia to strengthen its frameworks as really key to that response?
Absolutely. And as you've rightly pointed out, our colleagues in Canada and the United States are well ahead of us on these issues. And I think it would be far easier to coordinate our responses if we had if we adopted similar strategies, whether through legislation, through an envoy, through a dedicated office that is stable, that has expertise and experience in these matters, and a network of contacts both within Australia but also abroad. I think that would make it far easier for us to coordinate and manage our response, but also organise ourselves internally. Certainly when I was in Egypt, there was nothing along those lines, and I don't think we're significantly more developed. I mean, I know that there is a greater awareness, and the experiences of Sean and Chang and Kylie Moore-Gilbert have all helped focus minds on these issues. But it doesn't seem, apart from this committee, we don't seem to be significantly advanced in our thinking or our organisation, and so I think it is overdue.
And from your personal experience, recognising that a number of other countries did get involved in your case, do you have any observations of how other countries, even back then, were more advanced in dealing with your case or dealt with it in a different way to the Australian government, and we could learn some lessons there?
It's a really interesting question. I'm not sure that I'd necessarily say advanced, particularly at that point. Remember, I was in prison in 2014, and as Kylie pointed out, a lot of the US response really developed in 2014 when we saw the beheadings of a number of US nationals in Syria and Iraq. And so I don't know that at the time that I was in prison, it's true to say that they were more advanced, but they certainly used the levers that they had to apply pressure to Egypt. The State Department had a lot more direct contact with the Egyptians, as did the European Union, and diplomats use those networks, use those contacts, use the economic ties that those two administrations had with Egypt to apply pressure and leverage. I know that Australia worked with a number of other like-minded states, friendly states, particularly allies in the Middle East, to also apply pressure. So I think the thinking around this has clearly developed a lot more in the 10 years since I was imprisoned. But I think now, clearly, those states are far more advanced than we are. And so that's one reason why I really do welcome this committee's hearing.
Senator Ciccone, I might give you the call.
Thanks a lot, Chair. Look, I just really wanted to just ask one question, which was relating to what was said earlier in the opening statement around travel. And I note that in your submission you talk about this, about now that you've had a record against your name, what can we do as a government to be able to facilitate that should someone want to travel overseas or have that conviction recorded against their name, there is some form of documentation that can actually mention that there was circumstances around that. I just wanted to see whether you could elaborate a bit more to see how we could assist in our thinking when we put our report together.
I welcome the question, Senator. I'm not an expert on diplomatic notes, so I really don't have any specific knowledge of the kind of legal consequences or the legal options that may be available. But at the time that the New Zealand immigration authorities tried to kick me off the flight, and this, just to be clear on this, I wasn't intending to land in New Zealand or enter New Zealand. It was simply in transit. It was a flight that was from New York to Sydney via Auckland, and so I was frankly quite shocked to hear that they tried to kick me off the flight. And I was told I had to speak to the only reason I was able to get on the flight was that I called Chiara Spencer, who at the time was the head of the Consular Crisis Division, and I happened to have her mobile phone in my phone, her mobile number in my phone, and I called her and asked her to help, and she was able to speak to her contacts over the ditch and resolve it fairly quickly. But I was also told from the New Zealand authorities that it wouldn't happen again, that I wouldn't be allowed on the flight unless I had arranged a visa beforehand. Now, again, that's not necessarily a spectacularly complicated problem, but the issue that Kylie raised, the danger or the uncertainty that it presents in travel, and just keep in mind, I am still a convicted terrorist in the eyes of the Egyptian authorities, and I still have an outstanding prison sentence to serve. So the consequences of me flying through any country or being detained in any country that has an extradition treaty with Egypt are very serious indeed. And so from my perspective, some kind of note, and I know that you mentioned this earlier, some kind of letter, some kind of acknowledgement, official acknowledgement, because we can't deny the existence of that record, but it would be enormously helpful to have some kind of official note that allows us to say that the Australian government disregards this conviction for the purposes of official travel or official use or whatever, would be enormously beneficial. And as I said, for us at a personal level, there are serious consequences, but symbolically, again, I think it is really important for the Australian government to underline that we aren't going to play these games, that we're not going to continue to acknowledge the consequences of these kinds of convictions. And I think that is, symbolically, it also carries weight and significance.
And apart from overseas travel, have there been any other aspects of life here in Australia that you've encountered that, where they might say if you've got a conviction recorded, they might need, it prohibits you from doing something or applying for something?
No, I have to say it hasn't. And I think part of the reason in my case has been, frankly, that my case was so widely publicised at the time.
Yeah.
People know who I am. Yeah. I remember when I applied for a bank loan, when I bought a house a few years ago, the bank laughed when I raised the question of my conviction because it was very clear that they well knew who I was. But I know that.
Sorry, Raf, there wasn't on a financial document you had to say I'm convicted of terrorism, surely?
I had to declare it.
Wow.
I have an obligation to declare criminal records, and that is a record, and the consequences of lying or of not fully disclosing
For
that record.
Benefit, you would have been in fraud. Yeah, that's correct.
It would have been fraudulent, exactly, and so I do have to declare it. As I said, the bank understood and recognised it and disregarded it, but that's not true I'm sure, I doubt that that's true of all of others who've been detained in similar circumstances.
And to be honest, I've probably, like a lot of people, gone through certain scenarios where you've applied for something and you've just gone, I've got no convictions recorded, no. But someone like yourself, you have to answer truthfully and say yes.
Yes.
But there's and not just financial. I'm sure there'll be plenty of other instances where domestically these questions are asked. Anyway, it also might have to do with future employment, for instance. You might have to declare that you've got criminal convictions, that you're trying to apply for work. And
there are plenty of jobs that require some kind of security clearance or have requirements that people have no criminal records, and so yes, in that sense, it is potentially a big problem.
All right. Look, I just want to leave it there, but thank you so much for your time today. It does mean a lot to the committee. But Chair, I'll hand back the call to you.
Thank you very much, Senator Ciccone. And just before I ask Senator Steele-John if he has any questions, I just want to ask a follow-up around this issue of convictions. One of the issues is that the Australian government, for whatever reason, does not always find itself in a position where it is able to name up what you've been convicted with, what our own government's view on the conviction, the judicial process, in quotation marks, that you've been exposed to. And I mean, I've got a stack of media releases here from when various Australians who have been wrongfully detained overseas are returned, and not in every case do they name up that indeed that Australian was wrongfully detained, let alone what they were convicted of, let alone whether or not the government recognises that conviction as lawful. So you have this issue of at point of return, if the government, for whatever reason, thinks that it needs to maintain some sort of diplomatic relationship with the country that wrongfully arrested an Australian, do you see what I mean? If they're not willing to call it up at point of return, then it makes it more awkward to deal with this issue that you're describing. I mean, I think there's a role to play in naming it up when you get back into the country, but... Yeah,
and I also recognise some of the problems around ongoing diplomatic relations, but I tend to think that we may be a little bit overly sensitive on these issues. You know, I mean, I think it is possible for governments to make the distinction between these kinds of cases and ongoing diplomatic relations. I sometimes wonder whether we use the issue of foreign relations as a bit of a cover for avoiding assertive action. And I do believe, and you know, we can talk about this when it comes to media coverage as well, because I think that there's a similar issue there, that we tend to be perhaps risk averse, we tend to be a little bit shy of it. But I do think most foreign governments are capable of making that distinction and recognising that, you know, if there was a case of wrongful or arbitrary detention and you want to name it and issue some kind of document to declare, then I don't necessarily see that would have negative consequences.
Particularly once the case is resolved,
yes.
Right? Like, yeah. I'm sure the department will come in here and say that they have to manage these cases sensitively while they're ongoing, but at the point of return, yes. Surely there's not usually a good reason to continue the smoke and mirrors of whether or not an Australian's been wrongfully detained and wrongfully charged.
Yes, exactly. And I think it's, you know, there may always be cases that are a little bit obscure, but for the most part, I think it's pretty clear when wrongful detentions have taken place, and I think it's appropriate for the Australian government to call it out.
Because your sentence would have only finished December last year, wouldn't it?
Yes, yeah. Yes. But as I said, the sentence still still exists. Yeah, until I serve out, or there's the case is wiped out off the Egyptian books.
Senator Steele-John, did you have any questions?
Yes, indeed. Thanks, Chair. Thank you so much, Mr. Grestep. Can I ask you that there's been a lot of commentary around the role of public advocacy and media engagement in resolving matters in cases of wrongful detention. What's your view of the role that public advocacy and engagement with the media played in the resolution of your case particularly, and how that has influenced your view of the role that government should play in enabling, or at least not preventing, that advocacy taking place?
All right, cool. Just tell them to take a cell, won't be too long.
These issues generally.
Senator Steele-John, thank you very much for that question. For obvious reasons, as a journalist myself and as someone who was detained for my journalism and who was able to leverage significant media attention, you'll understand that I'm a lot more forthright on the question of media coverage and media attention. Let me make a few observations. My family, even though my family initially got the same advice as everyone else from DFAT typically does, and that is, please don't say anything, let us deal with these negotiations quietly and without the noise on the media. My family came to the view that the Egyptian authorities were perfectly capable of making the distinction between the nuanced messages that they were and negotiations that were taking place between their own diplomats and Australia's representatives. They were capable of making the distinction between recognising the subtle messages that were coming out of my family's mouths, and the far noisier and, frankly, at times rabid coverage that was in the press. My family felt that the press coverage, by and large, was rarely, if ever, negative. I believe that one of the reasons, and Sean and Kylie both mentioned this, or Kylie in particular I think mentioned this, that one of the reasons I escaped some of the worst excesses and abuses of the Egyptian prison system, and believe me, I saw plenty of evidence of it while I was there, but I was spared it largely because our case received so much attention, and the Egyptians were very, very aware of the potential outrage that would flow if we were in any way directly tortured or abused. We felt, my family felt, that the media coverage was rarely, if ever, negative in my case, and generally speaking, what it did was add energy to the discussions, add energy to the debate. Also, curiously, I remember having a conversation with a European diplomat after I was released. And I went to Europe. We were still technically on trial, and my colleagues were still in prison. And so I was still advocating for their release and for an end to our case. And I spoke to the European diplomat, and I asked him what we should be doing. And he said, keep going with the media coverage, the press, keep going with Amnesty International and Human Rights Watch, and keep going on Facebook and Twitter. And I said, look, the Egyptians don't give a damn about Facebook and Twitter or the media coverage, or Human Rights Watch for that matter. And the diplomat said, you're right, they don't, but I care. And because I care, it gives me the weight to go into my meetings with my Egyptian counterparts and say that I have this pressure on my back. I can't normalise our relations. We can't move on until this issue is resolved because of the pressure, the political and public pressure that I am under. And so I generally believe that media coverage is more helpful than it is a hindrance. I'm not saying that robust media coverage must always be the strategy, but I think it must be considered more aggressively or forthrightly. I think where it is destructive is where members of the public talk against DFAT or talk against the government, and I think that can be resolved often through careful coordination and communication with the families themselves, and through coordinated messaging. As I said, I recognise that what I've just been saying doesn't necessarily apply across the board, but I do think that the media coverage, particularly where it's with sympathetic journalists who understand the issues involved, can generally be far more helpful than is often assumed.
You might be on mute, Senator Steele-John.
Yes, I was. Yeah, thank you very much. Thanks, Mr. Grester. Can I just ask you, kind of as a follow-on to that? It seems from the evidence that we have heard so far as a committee that the advice given by the Australian government in relation to non-engagement with the media basically is often quite counterproductive, because it is a recourse that families engage with for a number of different reasons, but there's a bit of a pattern of a feeling, a well-founded feeling that the case isn't being given the priority that it should be, and so the family, engage in public advocacy and media engagement in order to be doing something. Would it be more useful, in your view, if the Australian government shifted from a kind of blanket no to some more actual guidelines around, if you are going to engage in this type of activity, these are our suggestions?
Yes, Senator Steele-John, I agree with that. It's impossible for me to know how media coverage influences negotiations. I've never been involved in diplomatic discussions or negotiations, so I really don't know. I can't speak to the impact of negative media coverage. But I do recognise that a lot of the times families go to the press out of frustration, out of a sense of a lack of movement or activity from DFAT, and that may or may not be justified. I do think engagement is always a far better option than disengagement, and I agree with you that constructive advice with families and support for families seeking to go to the media is always going to be a far better option than simply leaving families isolated and wanting to act out of frustration. But equally, I think that if families want to go to the press, I think that they should be allowed to speak out. I think one of my experiences is that the ability to speak lends validity to the experience and the suffering that the families are often going through. It gives it significance. It makes it valuable and worthwhile and makes them feel as though they're doing something. And I think that alone is a hugely important step for those family members. I just think that by and large, DFAT's reluctance to engage the media is counterproductive. It leads to frustration on the part of the families, and I think that a more thoughtful approach to the media and a willingness to engage the media is probably a far less damaging thing and an often more productive strategy than has generally been assumed until now.
And just finally, Mr. Grester, in terms of your experience of the support provided to you by the Australian government and the department post your return to Australia, Professor Turnell shared with us that they were provided with funding for 4 psych sessions, and that was it. There was no support in terms of mental health sessions to their family members, and the issue of financial assistance was also absent or hadn't really been engaged with. What was your experience of the mental health and financial assistance you were the recipient of from the Australian government post your arrival back into Australia, and also your family's experience of the services that were or weren't offered during your period of detention?
Senator, I have a very simple answer: none. I received no offers of psychological help or medical support from the Australian government, much less financial support, financial compensation. I was able to access some support through my former employer, but certainly nothing was forthcoming from the Australian government. Just on the question of compensation, I would like to think that there are mechanisms where perhaps if sanctions were applied in relation to arbitrary detentions, the proceeds of sanctions may be directed to the victims of arbitrary detention. Again, the symbolism of this, I think, is as important, if not more important, than the actual substance of those kinds of payments. But I believe that would be a very significant step forward as well.
Thank you, Mr. Grester. I just want to clarify, because I think anybody listening to these hearings would find your evidence shocking. And I want to make sure that I haven't misunderstood, but upon your return to Australia, you were offered no psychological assistance or financial support in terms of accessing a psychologist, a psychiatrist, anything from the Australian government.
That's correct.
That's disgraceful, and I think you can you could put a significant amount of money on that being one of our recommendations as a committee. I would say, because that doesn't meet the expectations I would say of the Australian community. Thank you for your work around these issues. Thank you for your evidence today. It's very much appreciated. It has been very valuable.
Thank you, Senator.
Thank you very much, Senator Stiljohn, and thank you, Professor Grester, for appearing here today and for your testimony. The committee would appreciate that responses to questions on notice be provided by Friday the 1st of November 2024, and the committee will now break for lunch. And for those online in particular, we will be reconvening at 2 p.m. as scheduled, so just a slightly shorter lunch break.
Thank you.
has been provided to you. For the Hansard record, will you please state your full name and the capacity in which you appear today?
Good afternoon, Senators. My name is Lee Toomey and I appear in my personal capacity.
Thank you very much, Ms Toomey. I now invite you to make a short opening statement, and at the conclusion of that, I'll invite members of the committee to ask questions.
Thank you very much. I thank the committee for the invitation to make a written submission to this inquiry and to give evidence today. I would like to acknowledge the Djarawar people, the traditional owners of the land where I join you from today, and I pay my respects to their elders past and present. I am a former chairperson of the UN Working Group on Arbitrary Detention, a special procedures mandate of the Human Rights Council, and I was a member of the group from 2015 to 2022. In that role, I have adopted opinions with my colleagues on cases of arbitrary detention for leverage purposes that were brought to the working group. The purpose of my submission is to inform the committee of the working group's practice in considering leverage cases. However, I should emphasise that I appear today in my personal capacity, and the views that I express do not necessarily represent those of previous and current working group members. While arbitrary detention for leverage is by no means a new phenomenon, the number of cases that the working group has received in the last 5 to 10 years suggests that the practice is ongoing and has not abated in any way. As the committee may know, the working group applies 5 categories in determining whether detention is arbitrary. In leverage cases, this typically involves an assessment of the detention under categories 1, 3 and 5. Category 1 is applicable when there is no legal basis for the detention. Category 3 applies when there are grave violations of the right to a fair trial. And Category 5 applies when the detention is based on a discriminatory ground, such as a person's foreign nationality. However, in some cases, Category 2 may also apply if the detaining state has carried out the detention to restrict the exercise of a person's rights. For example, the right to freedom of expression, as may be the case when journalists and researchers are detained for leverage purposes. A finding under any one or more of these categories will lead to a determination by the working group that the detention is arbitrary. The working group refers to arrest and detention that is contrary to international human rights law as arbitrary, as this is the term used in Article 9 of the International Covenant on Civil and Political Rights. For this reason, I respectfully suggest that the committee adopts the term arbitrary detention in its final report. The terms wrongful, illegal and unlawful are, in my view, already encompassed within the definition of arbitrary under international human rights law employed by the working group. Ultimately, though, whatever terminology the committee chooses to adopt, it would be preferable to have one term used across government departments and diplomatic posts to avoid confusion and to ensure that a consistent approach is taken in identifying and reacting to leverage cases. The working group's determination that a person has been detained because of their foreign nationality should be considered in my submission to the inquiry as conclusive evidence that the case is one involving leverage. However, not every case involving leverage is brought to the working group. In cases when there is no working group opinion, either because the case has not been submitted to the group or the detention is in its very early stages before the group has considered the case, there will be a need for Australia to develop criteria for assessing whether the detention of an Australian citizen is for a legitimate purpose or for the purpose of extracting a political or economic benefit. As previous witnesses have pointed out, each case is different, and there will be a number of factors involved in making this determination. In my submission to the inquiry, I have attempted to draw out some of these factors, which include, firstly, whether the working group or other UN bodies have found a pattern of cases of leverage in the state concerned. Secondly, the nature of the detainee's presence in the country. The working group has, for example, examined a number of cases where the detainee was in the country prior to being detained for entirely lawful purposes, such as study, work, travel, or visiting family. And thirdly, whether any statements have been made by the authorities to the media or the detainee themselves, suggesting that a concession is being sought. These are not formal criteria employed by the working group, but factors that I have distilled in my own scholarship from the working group's jurisprudence that might be helpful to this inquiry. I have included a link in my submission to a recent journal article of mine that outlines these factors in greater detail. Finally, while my evidence addresses the arbitrary detention of Australian citizens for leverage purposes, there are many other cases of arbitrary detention that do not involve attempts to seek a concession from another state. All cases of arbitrary detention are unacceptable, regardless of the nationality of those involved, and must be addressed as a matter of urgency. Thank you.
Thank you very much, Ms Toomey. First of all, I mean, I think it's quite obvious from the submissions that we've received and the testimony that we've heard so far that we need a very clear definition of what arbitrary detention is. And I'm using your phrase there because I had wrongful detention written down in my questions initially. So what do we need to consider to ensure that this definition correctly identifies somebody who has been arbitrarily detained?
Well, I think there will be a number of factors that Australia will have to take into account, Senator. And I think you could, if you decide to recommend a legislative route, I think you could embody those categories or factors to take into account within legislation. I would suggest they include a number of factors that I outlined in my opening statement. For example, whether there's been found to be a pattern of cases in the country, the nature of the detainee's presence, and also other factors such as what kind of law has been applied. The factors outlined in the Levinson Act as well, I think, could be very easily applied to situations like this. One thing I wanted to point out, Senators, is that I looked at the Levinson Act. I don't purport to be a great expert in that area, but I saw that a couple of the factors that the US takes into account in determining whether to act on cases of leverage involve, under particularly subsections 4 and 9 of Section 2, involve questioning whether someone has actually been detained for the exercise of their rights or whether they've been held in inhumane conditions. And I think while valuable, those factors alone aren't determinative. So the working group sees many cases in which people are detained under those circumstances. So I think if you were to embody factors in legislation, you might want to point out that the totality of the circumstances should be considered.
Speaking of the Levinson Act, beyond having that definition in that legislation, does that include a process to be used to assess and then classify whether somebody has been arbitrarily detained?
I don't know the answer to that, Senator. I'm not familiar enough with the legislation. I only know the definition of the factors, but I imagine it must do. I mean, there would have to be a decision maker, presumably at a high level, and a consultation as well. I noticed in the UK recently conducted a similar inquiry to that you're conducting today. And found that there should also be factors mentioned or factors listed that would be taken into account. And part of that process recommended was that the family would be consulted very closely in making the determination. And I thought that was an important point. If you make any recommendation to go down the legislative route, I would have thought it would be important to specify consultation with the family. The other thing that the UK mentioned in its report on stolen years was the importance of keeping family involved, but also keeping cases under review as well. I think that's quite important because you never know, while the working group sees cases where it's leverage from the outset, sometimes the facts change over time, and it's that would be a very good part of the process, I think, if you were to embody a requirement to keep matters under review.
That's a really good point. So even if in good faith a government has made a determination that one of their citizens detained overseas has not been arbitrarily detained at some point further down the track, and we assume that governments are going to manage these cases as consular cases if at a bare minimum, but if at some later point down the track they become aware of more information or the circumstances change, then they have the flexibility to be able to say, look, recognise that we didn't determined that this was a case of arbitrary detention at the outset, but now with the information that we have to hand, we are, and that enables that flexibility. You were talking about the need to consult with a wrongfully detained person's family for government to be able to make that assessment as to whether they have been wrongfully detained. Can you explain to the committee why that consultation is important? What information are you looking at getting out of a person's family in that instance that would inform a government to make that categorisation?
I think it would be largely emotional support, Senator, just keeping the family involved. From our consultations with families, we hear all the time that families are sometimes kept out of the loop, and I think involving them in that consultation may well help. But also I think it's important to keep in mind that families are going to be the ones who probably have the most access, particularly if consular access has been denied, to the detainee. They know their needs, they're familiar with the situation, they may even be able to speak the language when a consular access officer does not. So I think they will have access, they often have access in the working group's experience to the lawyers as well. They will pay for and engage the lawyers. So it may well be that they have information about the conditions of detention that a person's been held in. As I mentioned in my opening statement, one of the factors is whether any statements have been made to the detainee or publicly about the case, or whether any concession is being sought and linked to any policy objective. And I think that kind of information is likely to come out through the families. In some of the cases, Senator, that we've had in the working group, statements were made directly by government officials to the detainee, suggesting that leverage is being sought. And I think it's that kind of information that should be kept an eye on throughout the detention, so that, and it's likely to come from families and lawyers and the detainee themselves.
And we've certainly heard from other witnesses, particularly family members of Australians who have been wrongfully or arbitrarily detained overseas, and their evidence was, and I'm paraphrasing a little bit, that they felt that if they as family members hadn't have been advocating in the manner that they were, or in some cases indeed on the ground in the country where their family member had been detained, that the case wouldn't have progressed as quickly as it did. So I think that's an important consideration there. Can we just take a step back from what we've been talking about, the ability of family members, for example, to get information about people who have been detained and provide that to government. How difficult is it when a person, from any country, in any country, has been detained for the government of their country of origin to be able to get information quickly in order to be able to make an assessment of whether they have been arbitrarily detained? I know that probably changes depending on the country that you're talking about, but generally speaking, I'm sure the government officials will come to this committee and say it takes us months and months and months to engage with the country that has detained an Australian to figure out the facts of the case, the process that they're going through. But anecdotally, how difficult do you think that process is, and how can we in Australia strengthen our framework to make that process easier, whether it's sharing information with other like-mindeds that might have intel on our citizens detained overseas or anything along those lines?
Yeah, that's a very good question, Senator. I think just from observation anecdotally of the working group's opinions, we, as you would appreciate, tend to see human rights violations and human rights being breached rather than observed. So we see the worst of cases, I think it's fair to say, and I think generally speaking it's very difficult to get that kind of information. it does depend on the context and on the country, as you say. But one critical factor that I'd like to emphasise, that to answer your question about what could be done, would be to, in every case, try as much as possible, and in fact even embody a right to consular assistance in legislation to get that access, because that, in our experience in the working group, that's absolutely essential. It's through that consular access that you can not only find out information, but you can provide legal assistance, interpreters, information on the law, psychological support, if needed during a trial, evidence of good behaviour and on sentencing. I think that consular access is really key, as well as assisting in getting legal representatives. The working groups pointed out on a number of occasions how essential that is to have proper legal assistance in place to get the kind of information you suggest. But overall, I think it's probably very difficult. Most states in these situations either deny or delay consular access, and the working group would find a violation of due process in that circumstance. It can be very difficult. We see in the petitions sometimes people explaining why they can't get access to full information.
Dr. Moore-Gilbert, in her testimony earlier, was saying that often it's only once an individual has been formally charged that consular access is afforded to them, and in reality there can be months and months and months leading up to that process from, you know, their point of arrest to actually being charged with a crime by whatever quasi-judicial system they're being subjected to. Again, I guess that makes it, that means that there is a lengthy space of time where governments could be fact-finding or getting information about a specific case in anticipation of something more serious happening, yes?
Yes, absolutely. And I think it's important not to forget either that, as other witnesses have pointed out, many human rights violations occur during that period. Yeah. Actually, it's a really essential period. Acting quickly will mitigate some of those risks, but waiting months and months, and I believe that does happen, delays in allowing consular access, we've certainly seen cases of those, but, you know, someone is at much higher risk of torture and ill treatment, not having access to lawyers, not being brought before a court, for example, to have their circumstances considered. So I would say that's a definite reason for lack of information, but it's also really crucial to act quickly and to take into account the totality of the circumstances, make a decision as soon as possible with the flexibility to change later should new facts arise.
I want to turn to the question of sanctions, and we heard from witnesses earlier today that in Canada, as part of their legislative response to the issue of arbitrary detention, they have specified in that legislation, as I understand it, sanctions that can and should be applied to individuals within regimes that are arbitrarily detaining Canadians. We have Magnitsky-style sanctions here in Australia, which could arguably be used to sanction individuals that have likewise been engaging in the process, in the conduct rather, of arbitrary detention. Do you have a view on whether our Magnitsky framework is sufficient to be our number one sanctioning tool in this regard, or do you think that there needs to be some other sort of sanctioning device that government can use for cases of arbitrary detention?
I don't know a great deal about the sanctions regime, Senator. It hasn't come up in cases before the working group. But what I would say, and I didn't hear any other witnesses mention this, I think there's a largely overlooked mechanism in the working group to address these cases of arbitrary detention. I mean, I heard you speaking this morning about a reticence of states to apply sanctions, and generally speaking, as an observer, I would say that's the case. But you have an international body that's independent. It's almost at its 34th year of operation with a very detailed definition of arbitrary detention. I think that's something that I think sanctions should certainly be applied, but I think in complex cases it's going to take a range of measures to be applied. And I'd urge the committee in the strongest terms not to overlook the working group as one of those mechanisms that may help. I mean, having an independent finding may well help states that would be reluctant to interfere in a state's sovereign matters to actually say, look, we have this finding and we will proceed with whatever factors have been outlined in legislation or otherwise. And I think the benefit of having the working group involved, Senator, is more than that. I think, if I remember correctly, you were asking this morning about how do you combat the narrative around someone having been convicted. And I think that the working group is one of those mechanisms that has a big role to play, because a finding that someone has just been detained for leverage because of their foreign nationality has somewhat of a restorative role. It takes away that narrative on behalf of a state being able to say that. So in all of the discussions, I didn't hear that reference, but I wanted to emphasise it today. Sanctions, certainly. And I think also people have mentioned bringing cases to international fora, using the media where it's appropriate, and again in consultation with the family. So I think it's such a complicated and pernicious problem that a variety of measures are going to have to be put in place, including sanctions. Sanctions probably alone may not be enough. It's got to raise that diplomatic cost sufficiently that it will no longer continue.
I agree. Ms. Toomey, why do you think Western democracies are so averse to publicly calling out authoritarian regimes who are using hostage diplomacy as political leverage?
I think there may be, in particular, one reason behind it. I mean, you see in the news when a state calls out a human rights violation, it doesn't necessarily have to be arbitrary detention, it could be anything. Another state will respond by saying, well, look at your own violations, you know, sort of in retaliation. I wonder if that doesn't play a role, actually, because very few states are without human rights violations themselves, and there may be a reticence there to call out other states in case states do, as they have in the past, said, well, look at your own situation. I think the fact that I've done it for 7 years, Senator, and I can tell you that it's not always easy to determine whether detention is arbitrary or not. It can be tricky, and I think the lack of either a legislative or other framework for Australia and its allies to do this is playing into that hesitation, because you don't want to call it out if in fact it's not. I think Australia and its allies know where it wants to go in terms of stopping this practice, but doesn't necessarily have the framework or knowledge to get there. And I think the working group could play a big role in that by its determination that a situation is arbitrary.
There is a difference, though, isn't there, between individual countries engaging in the behaviour that you've just outlined and others engaging in that behaviour against foreign citizens as political leverage in order to achieve some sort of diplomatic outcome?
Well, certainly there is, and I don't mean to imply there isn't. It's a massive red line that states cross when they detain someone as a bargaining chip. There's no doubt about that. But if you're prepared to cross that line, I imagine it wouldn't be beyond the realm of possibilities that states would look to other states' violations as well, no matter the hypocrisy involved in doing that.
Do you think that publicly calling out a regime that is using hostage diplomacy is a preventative measure that Western democracies can take to deter this practice from occurring?
I think it can be. I think you would always want to consult with the families as to whether that's an appropriate strategy. One of the things we've seen in the working group is how vulnerable people are when they're in detention, and I think you would want to take into account all of the circumstances before doing that. But certainly the working group makes its opinions and findings on arbitrary detention public, and that can be helpful. It can often be a strategy for local human rights defenders as well as governments to take up the case. Depends on every case, but I certainly wouldn't discount it. I heard with some dismay that there were situations where people were advised not to go to the media. I would suggest, as many others have, that it should be flexible. We know of cases in the working group where the opinions have been taken up by advocates and it has worked well. So calling attention to it can be a very effective strategy.
I don't think I have any more questions for you, Ms Toomey. I'm just checking to see if any other senators do, and we are very close to time. No one's jumping, so we might leave it there. Thank you very much for appearing for the committee today. I don't think you took any questions on notice, but if you did, the responses to those are due by Friday, the 1st of November 2024. And now I ask that you disconnect from the video conference, and if you want to keep watching the hearing, you can do so on the Australian Parliament website. Thank you.
Thank you very much.
Thanks. We might just suspend the committee for a moment while we wait for our next witness to join. Late, and I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. Will you please state your full name and the capacity in which you appear today?
Lei Chang. Lei is my first name and Chang is my surname. And I'm both a A-WADA founding member and also appearing as an individual.
Ms Chang, I'll now invite you to make a short opening statement, and at the conclusion of any remarks, I'll invite members of the committee to ask questions.
Thank you. I've read all of the submissions that have already been made, and my will be very much focused on my personal experience. Obviously, Kylie Moore-Gilbert has done a fantastic job with the A-WADA submission, which I fully endorse. And I want to start by saying that prevention of wrongful arbitrary detention is better than cure. So deterrence is of the utmost importance. And on that, we really need to use unequivocal language when it comes to making our zero tolerance stance clear to bad actors about this sort of behaviour, which is totally against everything we stand for. And from personal experience, I know that people who did do this are very afraid of having their personal identities exposed, to having any repercussions on their families or businesses. So I think Magnitsky sanctions are useful. I'm extremely grateful to how I've been supported and helped, and my release secured thanks to DFAT. And I just want to be able to contribute to better outcomes for other people who may be who may be going through the same awful things that I went through. And of the bullet points, I'm pretty embarrassed that my submission was very brief compared to the very comprehensive submissions from other people, which read like papers. But these are things that I feel very strongly about, which is where some countries would use smear campaigns to taint the detainee's name and reputation, which affects the family, it affects the detainee, of course. And to date, we haven't seen any criticism of that sort of behaviour, because it's absolute slander. Something else that might help detainees is more professional legal advice or knowledge when first incarcerated, because information is critical for making decisions. And when I was first detained and kept in extreme isolation, I was only given a list of lawyers from which to choose my legal counsel. Of course, I'm very skeptical about how much legal counsel can achieve, but it led to a lot of crossed lines, misunderstanding, including, the suffering of my relatives, my family, in trying to choose the best lawyer for me. So just a list of lawyers is inadequate in complex cases. And I had another irony, which is a stranger who wrote to Minister Wong could get her message to me, but my friends didn't know how to contact me. And that sort of communication can really help a detainee's mental state. Then there is the fact that sometimes families' wishes and the detainee's wishes contradict. And when you are helpless and voiceless, the last thing you want is for well-meaning relatives or whoever to be overriding your own wishes. And that did happen, or almost happened, when I tried to send out a message that I wanted publicised. So the detainee's voice needs respect. And I think sometimes because our DFAT officers are very respectful of the family, sometimes they perhaps forget that the detainee is really in a worse position. I want to highlight how coordination between state and federal governments might have assisted my family. Not that I'm ungrateful, I'm extremely grateful. It's just falling through the cracks. When my mother was in charge of looking after the two kids, she wasn't capable, but nobody knew it, and everyone suffered as a result. And I know that for federal government, this is where coordination would have helped, because this is within the gambit of social services in Victoria. So I do have this in my submission, and I think I've gone over 5 minutes. I also wished that there was a support network of detainees' families, and of course, as the submission that A-WADA made says about consular officers' knowledge transfer and hopefully minimal turnover, I would just say that is so important. And as for post-release support, both Sean and I have talked about banking issues and tax issues, because when you've been away and you come back, and it's quite traumatizing to feel like you're unable to carry out those life admin tasks. And assistance would be very helpful, as well as some sort of note that explains what we've been through. So when it comes to applying for visas or explaining late tax payments, it can be helpful. Yes, we can tell the story ourselves, but it just adds to the humiliation, I guess. And yeah, sorry about this.
Not at all, Ms. Chang. Thank you very much for your testimony, and I recognise that as one of the most recent returned Australians who have been wrongfully detained overseas who's provided testimony to this committee, it is quite obviously still a very raw experience for you, and we really appreciate you being brave enough to come and appear before the committee today and provide that testimony. It's very powerful.
Sorry, just one last thing.
Thank you.
Sorry, just one last thing.
Of course.
And I'll do the same for you when you come on the show. I'm kidding. When just recently, for example, for me, I still have ties to China and assets in China. And just an example of the a punishment that extends way beyond the sentence is I've had lawyers in China afraid to do conveyancing or any, handle any legal affairs for me because of the smear campaign against me. So that is, extended trauma that nobody needs. Thank you.
Thank you very much. I can only imagine how dreadful that must be for you. Just first and foremost, we heard from Professor Peter Grester earlier about, notwithstanding the fact that he returned from his experience more than 10 years ago now, he was saying that the government at that point in time only provided a couple of psychologist appointments to him to start to deal with what he'd been through, and I use that term purposefully because I don't think there's any way you could do much more than only start to deal with your trauma in a couple of appointments with a psychologist. What mental health support has the government made available to you since you have returned from China?
4 therapist sessions.
4?
Yes.
That's not a great deal, is it?
Well, I guess I'm just very grateful that I was given 4. Kylie got none.
Yes, that's the sad thing, isn't it? My next question is, and I think I know the answer, do you think is 4 sessions adequate?
No.
No, absolutely not. And I also would have thought the fact that you've received a number of sessions as psychological support and others, like you say, Kylie has received none, that's less than ideal in the situation as well, if there's not some understanding of exactly what you're going to be provided with on the way home.
Yeah.
We also heard, and I think it was from Professor Grester this morning as well, Professor Turnell might have touched on this too, some of the difficulties that you all experience when you come back to Australia and you're trying to apply for a bank loan or apply for a credit card or apply for a job, and you're obviously in this position where you have to, you're all very honest people, and you declare that you've been subjected to a legal process overseas, and the outcome of what that legal process is. For the committee, could you just outline a couple of practical examples of that sort of thing that you've had to experience? Because I think a lot of Australians, and I think one of my colleagues was talking about this earlier, wouldn't even, we all tick the box that says, yes, we've never broken the law, because we haven't, but a lot of Australians wouldn't necessarily understand just how difficult that is, particularly in circumstances where you haven't been found guilty of a law in Australia.
Yeah, it puts us in a moral quandary. Do we lie, or do we not, get a visa? I worry about that. So that's, again, the extended punishment.
Yeah. I also wanted to touch on the issue of assistance and support that is provided to families, and I think you touched on something really interesting and important in your opening statement, that DFAT, federal government, was aware of your case, but the state government where your family resides I very much doubt they had all of the details of your case and were in a position to even know what kind of support they could potentially provide to your family in that situation. Could you provide for the committee a bit more of a summary of what that support could have looked like and how you think that disconnect between DFAT or federal government and state government could be strengthened or could be alleviated, the disconnect?
Well, I think one of the submissions mentioned exemptions for privacy could be made for consular services. I think DFAT is hamstrung by privacy concerns at all times, to the point of the detainees' frustration, because we want what's best for us and best for the families. If we say there's no problem with privacy, go ahead and do it. So if we can give okay, then whether it's providing info to the media or allowing social services, local social services, to contact my family, to give them my situation rundown, by all means. I would much have preferred my mum's plight. Seriously, a 75-year-old hoarding disorder pensioner looking after 2 kids in the COVID lockdown and breaking 5 ribs and didn't even know she had diabetes until my daughter went for a blood test. Yeah, that was how she discovered it.
Yes, it's
And in cases where it's obvious that, because I'm a single mum and the kids were with my mum, she's doing it tough.
And I think this is something that we perhaps haven't heard in the same way from other witnesses that have been wrongfully detained, that
Yes.
some of, they talk about the impact on their families at home, and obviously it's very stressful for them. But in your personal situation where you were the primary caregiver for your family, and then all of a sudden you're not there anymore, at what point does somebody within government pick up the phone and say, I think this family needs a bit of support here?
Yeah. My mum didn't know what was available to her. Not because, her daughter was having trouble overseas, just for a normal pensioner. She doesn't know. So, yeah.
Yeah, I think it's very easy for all of us, particularly parliamentarians that deal with the bureaucracy each and every day, to we forget sometimes that most people don't ever really have to have an interaction with government beyond, paying their tax return. And then if suddenly you're in a situation where you do have to have, you are effectively forced to engage with government to receive the support that you need, people aren't good at figuring that out at the best of times, in my personal experience, but particularly when you are going through something as traumatic as having had a family member wrongfully detained overseas. So I think that is a really important point. To some of the details of your case, Ms. Chang, were you provided with a point person within Australian government while you were in detention?
No. I just saw the consul officers as they appeared.
Mm-hmm. And was it the same officer each time?
There was turnover, but there was one officer who came for most of the visits, and that made it so much more helpful because then they know your whole story, and because you're having to convey your innermost thoughts through these people, and if you don't have rapport with them, it's very hard to, dictate love letters through people. That's all you can do.
Did the individual who you saw most regularly, or even any of the other people from the embassy, I'm guessing, that were dealing with your case, do you know if they had specific expertise in hostage diplomacy?
I don't know. I used to just wish that they could transcribe accurately because I saw that every time I spoke at the visits, there were 3 to 4 people all writing furiously. And I just hoped that they could write accurately and very quickly. So I didn't have to repeat myself. I didn't know what training they might have been given in trauma and whatnot. So that would definitely be helpful.
Yes, we had the conversation at the last hearing that most people who go and work for DFAT are not doing so just chomping at the bit to be able to deal with hostage diplomacy cases at some point through their careers. So they're not necessarily going, and I'm not saying that they don't do a good job. I know that they do, but it's not a department that's geared for trauma counselling, and that's arguably a skill that they need to, that somewhere in government needs to develop at some point. You touched a bit on some of the experiences that you've had dealing with property back in China and the like since you've been returned home, and it just sort of sparked a thought that when we were talking with Dr. Moore-Gilbert earlier today, she was talking about the fact that I think the IRGC hacked some of her personal information once she'd returned back to Australia. I know that's sort of slightly different, but this ongoing issue of the relationship between you and the country that detained you, did you receive any briefings from our security agencies when you returned to Australia to just, at the very least, describe to you the risk situation that you were in and some potential mitigating factors that you could take into account to protect yourself?
I was given a briefing, but the crazy thing is when the embassy got me a phone ahead of my release, the phone was with the Ministry of State Security for 3 days because they refused to give it to me. And then I used this phone for months until our security agency said, "Oh, that's not a good idea. Give us the phone." So I wish this had been discovered earlier, so any possible, breaches might have been avoided.
Hopefully that's the first thing that they brief returned wrongful detainees on from now on is don't use any device that might have been held for an extended period of time by the regime that wrongfully detained you. I'm wary of the time. Senator Ciccone, I might hand the call over to you now, if that's all right.
Thank you, Chair.
Thank you.
Chang, thank you for your time today. I was just watching you before on Sky News. I thought we might do a live cross, but here we are anyway. Can I just commend you as well and your resilience? I know with your family here, it would be your worst nightmare, but can I just say thank you for what you have said to date? Because
thank you for doing this.
Because what you and others, we obviously other witnesses today and in our previous hearing, help us as policymakers, as lawmakers to make changes along the way and try and have a better system than what we have encountered. Can I also just ask you, just on the other point about the question from the chair around the telephone, and I note in your submission you talk about a debrief with DFAT, but also with ASIO, and I wanted to understand why ASIO, but I probably have a better understanding now. Well, I'm assuming it's because of maybe things that you had come across, or maybe how things like the embassy providing things like a device but not actually going through a thorough process to make sure that whatever they do hand to you is not then used against you, I guess. I'm a bit surprised from what you've just shared with us that they would have given you a device, the intelligence gathering. But can I just ask you just to explain to us why did you mention ASIO in your submission?
Why did I? Because we might have information and we might need advice on how to protect ourselves and what happens, for example, when we go abroad, when we go through countries that might have extradition treaties with our detaining country.
And do you mean that as someone who has gone through the scenario of being wrongfully detained, or do you think is it more for journalists, for other people going overseas? I'm just trying to understand, are you referring about your specific circumstances or more broadly?
returning or released detainees.
Yeah, okay. And obviously you've shared some stuff with us, which I'm sure would be of value. Is that information something that you have shared with DFAT or did share with DFAT? Was there a debrief with DFAT when you returned?
I actually pushed them for it.
All right.
Actually ahead of the Prime Minister's visit.
And you mentioned ties with China, and probably, I'm assuming, still extended family back in China. Yeah. As part of the discussion that we've been having as a committee around, maybe a special envoy or a central point, is that something that you would envisage that would assist and bolster maybe the government of the day to not just to help you or your family in Australia, but also a central point for others to contact if they have any tip-offs or any information they'd like to share with officials here in Australia, like in your case. And it might be a bit more difficult, but let's say there was someone in China that wanted to share something with us here in Australia, that they could go through a special envoy or one official. Is that something that you had in mind as part of your submission to the committee?
Of course, yes. I think a central point of contact would be tremendously useful, because we all know what it's like to deal with bureaucracy. You always get kicked around, and then you just lose hope and you forget about it.
Yeah. And I know you've spoken at length, and I want to ask you about, since you've been here, the support that you've either had or would like more of. But the one thing I've asked Peter and Sean and Kylie was also around, have things improved, I guess, over the years? Do you believe that DFAT and DFAT officials are making greater improvements around our processes from what you're seeing from other cases that are appearing?
Well, I think Kylie has done so much for this cause by pushing for change. And without her, I don't think I would have gotten the therapist's sessions and the medical checkup. So we can look after our detainees better.
And whilst you've been back, is that something that you're now finding difficult in accessing through your GPs or other healthcare providers? Are you finding difficulty in trying to gain enough support?
Well,
access to support?
That's where this super letter comes in, an explanatory note that I can give to a GP or some other, or a therapist or the ATO, just to, instead of us having to scratch at the scabs.
Yeah, like there's something there that's already there that you don't need to repeat every time that an agency or someone keeps asking for more information. Yeah. That's fair enough.
And then you just like you're fishing for sympathy or something.
So, I mean, you mentioned the ATO. I mean, not that I'm trying to delve into your personal circumstances here, but have they tried to seek information from you from years ago now? Like if you're trying to do your taxes, for instance, I mean, are they demanding that you hand over some records? Or
I've called them to ask for a grace period, and this is where I had to explain, and I'm not sure to this day whether the woman at the end of the phone understood, because sometimes I mention incarceration or detention and people think, oh, she was stuck there because of COVID.
Oh, really? Well, I'm hoping someone's watching this might be going, oh, actually, we might need to fix this. But, okay, well, that's interesting to know. Have there been any other difficulties with other government agencies than you've encountered? Like the ATO? No?
I feel so behind in all the admin stuff. And just have to drop those balls for now and deal with them as I as I become more equipped.
Yeah. And I guess in terms of any other engagement with DFAT to date, have you had engagement with them of late or over the last 6 to 12 months about either further debriefs or just even them asking you questions around improvements in policy?
I had a meeting with them in January. Yeah. And I have those lovely consular officers who had come to visit me, and I've been able to meet them, but not official meetings as such. And I'm super grateful already, so...
Yeah. I mean, they do a good job and trying to deal with a very difficult situation, but, you know, it might be worth something as well too after today's hearing. Maybe the Chair and I have a chat about how we sort of think about, you know, if there's anyone watching today, how that we can help you out with any of these life administration issues that you're encountering. But and I know we also spoke earlier with Peter Reston about people who want to travel overseas and obviously technically will have a conviction recorded against their name in some countries, you know, won't understand or need maybe a letter from government to the day to understand why is it that person has a conviction, but putting the context around it. Is that something that you think is worthwhile us looking at in a bit more detail?
For sure. I think it's much achievable and it makes a great deal of difference.
Yeah, and I think Peter talks about having an official note attached to either your passport or the visa.
Yeah, for sure.
Sorry.
I guess I just reiterate where detainees' children are concerned to be mindful of, you know, specific assistance. I would really have liked my children to have had more support.
Yeah, and I guess worth also making sure that children or parents like yourself aren't in a similar position in years later on when they're a bit older and travel and not being caught up when they're at an airport. Yeah. And in terms of your family in China, is there anything from their end that they've sort of flagged that they'd like to see as improvements? Happy to leave it with you and how much you want to detail with us in this public forum, but I'm just mindful too that in some countries that the families themselves need to be careful about what they say or do.
I have family that's afraid to acknowledge I'm back.
Yep.
And this week when I saw on Chinese social media some of our MPs' posts that were very gleeful about the blingy China, the high-speed rail, the Great Wall, and I love that we are back to engaging and our business ties are back to where they should be, but I think at all times we should be mindful of the other side of the Chinese regime. And, you know, it's a balance.
It is, and that was another thing I did ask earlier in the day too. It's about that fine balance, the approach about speaking out publicly, but also trying to have those diplomatic channels in the background. Yeah. But equally, restoring trade does help. History shows that where you have strong trade, usually there are strong dialogue on many diplomatic fronts as well too. And I think that both go hand in hand, but it's important that we don't also are oblivious to the fact that there are still, you know, human rights issues in some countries that we need to be mindful of.
Yeah. So I made a cheeky comment on this. I said,
just one.
This is on the Chinese social media platform where this MP was posting. I said, ask to see the Ministry of State Security Detention Centre where Dr. Young and I were. And I think the next post was a bit more mindful of that and said, yes, we talked about opportunities, but we talked about, our areas of concern as well.
Well, can I just thank you again for appearing? I know it can be very distressing to relive, but also very important, I think, for our parliamentary system to be able to get that evidence on the public record. And I just want to thank you for making the time. I know you've been busy in the Sky studios, but I'm sure, like Senator Chandler, maybe make an appearance one day on your show. But anyway, thank you again for your time. And hopefully you and your family are doing okay on a much more serious and personal note as well too.
Yep.
But please don't hesitate to maybe sing it to both us if you need any ideas or help with navigating some of those life administration issues with government.
My joke is detention or taxes. Oh, it's a tough call.
Look after yourself. Thank you. Thanks, Chair.
Thanks, Claire. Thanks, Raf.
Thank you very much, Ms Chang, for appearing for the committee today. I don't think you took any questions on notice, but if you did, we will require responses by Friday the 1st of November 2024. And now if you would like to disconnect from the video conference, you can keep listening on the APH website, but I'm sure you've got a news coverage that you need to get away to do. So thank you so much. Thanks for appearing today. The committee will now take a short break and will be resuming at 3:30 p.m. We'll now reconvene a little earlier than anticipated because we do have one of our next witnesses on the line, Ms. Lara Simons from Hostage International. Welcome, Ms. Simons, to the committee hearing today. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, could you please state your full name and the capacity in which you appear today?
My name is Lara Simons. I'm the CEO of Hostage International and I'm appearing on behalf of Hostage International.
Thank you very much, Ms. Simons. I now invite you to make a short opening statement, and at the conclusion of any remarks, I'll invite members of the committee to ask questions.
Thank you. And thank you to the Senate Foreign Affairs, Defence and Trade References Committee for the invitation to give evidence to this inquiry today. Hostage International is a charity which provides information, guidance, emotional and practical support to the families of those who've been kidnapped or arbitrarily detained, and to former hostages or detainees following their release. We provide this support internationally, including in Australia, where we have trained caseworkers and a network of service providers, including psychologists and lawyers. In the first half of our 20-year existence, our work focused on cases of kidnap for ransom, but in the last 8 years, we've seen a shift towards arbitrary detention, which now constitutes approximately 70% of our casework. In the last 5 years, we have supported 50 individuals affected by arbitrary detention, 13 of whom have been Australians. Hostage International supports and applauds most of the recommendations in other submissions to this inquiry. At the same time, we are aware that many of those recommendations may have limited impact on the timing or speed of release in cases of arbitrary detention. We support the recommendations being made to this committee foremost because of the very real and beneficial impact they can have on the family and the detainee. Through our work, we see the huge suffering that families and detainees experience in arbitrary detentions. The psychological, financial and practical repercussions are significant and often long-term. During the period of detention, the family and detainee feel powerless, and the one entity they need to rely on and want to trust is their home government. But many feel terribly let down, and this disappointment lingers for years afterwards. Appointing a senior official with responsibility and authority to lead on these cases would signal to families that the Australian government is taking the matter seriously and dedicating expert resources to the case. And it's important that this official has longevity in the role, a team of experts behind them, direct access to the most senior levels of government, and, importantly, regular and direct contact with the family. And this can be alongside the family liaison members of their team. They also need to be the right personality with an ability to build rapport and show empathy. SPIHA in the US is a good example of this senior official role. Roger Carstens has built up a vast knowledge about arbitrary detentions over his years as Special Envoy, and he's able to speak to families authoritatively and compassionately about all aspects of a case, giving the family confidence that the government knows what it's doing. Where there is no such permanent senior official for arbitrary detention, as in Australia, families meet with a desk officer or case manager who may have been in the role for a short time and usually has no prior experience of arbitrary detention. Families are looking to their government to understand the complexities of these cases, which are well outside their personal experience. But the desk officer comes across as lacking authority and knowledge, which undermines the family's confidence. The desk officer is largely a mouthpiece for government policy, which is implemented and communicated without a full understanding of the possible nuances involved, say, in the risks or benefits of publicity, without flexibility to look at the case from different perspectives, and sometimes without empathy. So from our perspective, the appointment of a senior official supported by a knowledgeable team, which is accountable to the families, would be a huge improvement for the current family experience. Hostage International also supports clear and transparent criteria for triggering a more speedy government response to what is likely to be a wrongful detention. This is necessary to safeguard the detainee. If the Australian government waits until the detaining state has completed their legal process and or made clear they are seeking a concession for release before they categorise the case, this could take many months and sometimes years. No Australian detainee should be left exposed to the obvious risks that such a delay entails. One immediate red flag in an arbitrary detention case is the denial of consular access to the detainee by the detaining state. This is a breach of the Vienna Convention on Consular Relations and should be a trigger, along with other factors, for escalation by the Australian government and rapid investigation into whether this could be a case of wrongful detention. Too often, families are told by their government that they have requested consular access and that it has been denied, without offering any further action or recognition of what this means for the detainee or indeed the family. There should be clear and more effective next steps. I haven't time to address all the recommendations. However, crucially, where post-release care is concerned, a better understanding by DFAT of the needs of former detainees and what NGOs in Australia can offer is required. DFAT's submission mentions referring released detainees to Services Australia, but makes no mention of Hostage International, for example, whose services are tailored to the trauma and practical issues specifically faced by hostages and detainees. The fact DFAT have offered 4 trauma sessions to more recently released detainees may sound like an improvement, but delivering something half-developed, 4 sessions is by no means enough. They may end up doing more harm than good. Trauma therapy and the broader rehabilitation programme needs to be consistent and continuous. So ideally, it should be signposted to those better able to deliver it. With all of these recommendations, what is critical is the regularity and fullness of communication with the family and detainee. That communication will only be effective if undertaken by the right individuals who have the necessary knowledge, experience, empathy, and authority, and who are operating within a clear policy framework. Thank you.
Thank you very much, Ms Simons. We also have Ms Harth on the line now from Safeguard Defenders. Ms Harth, for the purpose of Hansard, could you please state your name and the capacity in which you appear today?
Hi, good morning. I'm Laura Hart, Campaign Director with Safeguard Defenders.
Thank you very much, Ms Hart. I now invite you to make a short opening statement.
Thank you. Safeguard Defenders is a Spain-based NGO focused on judicial and law enforcement issues in the People's Republic of China and how those issues increasingly spill over into the wider world as the PRC seeks to reshape the international rules-based order. Prior to our establishment in Spain, we were based in Beijing. Our insights are therefore not only the product of extensive research, but based on the unfortunate personal experience of our members as well. I'd like to start by stressing the difficulty in assessing the wrongfulness of any detention in China, as its security and judicial apparatus are completely subservient to the Chinese Communist Party. Under Xi Jinping in particular, there is no sector in society that is not deemed a national security interest, including the economy. Furthermore, the CCP does not shy away from detaining individuals and fabricating charges as a means of gaining leverage over other countries, companies, and even individuals. This vastly expands the risk for foreign citizens traveling to or working in the PRC. Now, this legal uncertainty stands in stark contrast to the certainty that any detainee or prisoner in the PRC will be subject to torture or other inhuman and degrading treatment, stands no chance of having a fair and impartial trial, will see their consular rights violated, and is at risk of enforced disappearance in a notorious residential surveillance at a designated location. In October 22, the European Court of Human Rights ruled against the extradition of an individual to the PRC on the grounds that, and I quote, the extent to which torture and other forms of ill treatment were credibly and consistently reported to be used in Chinese detention facilities and penitentiaries could be equated to the existence of a general situation of violence. UN special procedures have repeatedly echoed similar sentiments, noting the existence in the state concerned of a consistent pattern of gross, flagrant, or mass violations of human rights. Conviction rates in the PRC are consistently just shy of 100%. Detainees may be denied access to lawyers of their choice, lawyers may be denied access to their clients, or become themselves the target of repression. In blatant violation of international norms and bilateral treaties, as my colleague just said, consular rights are routinely restricted, including by pressuring detainees to refrain from the legitimate exercise of their rights. Especially in so-called national security cases, legitimate access to the detainee and presence at the trial is often denied. Last but not least, as for an overwhelming number of Chinese, foreign citizens run the very real risk of spending a 6-month stint in the system of residential surveillance at a designated location, or RSDL. Colloquially called black jails that are part of the pre-arrest investigative process, they consist in the complete isolation of the individual from the outside world. UN procedures have repeatedly called for its abolishment, stating the system amounts to enforced disappearances, arbitrary detention, and, if longer than 2 weeks, constitutes torture in and of itself, while creating an environment conducive to further torture and other inhuman and degrading treatment. To their credit, the recently updated Australian government Smart Traveller Advice for China lists many of the risks associated with travel to the PRC. However, we highly recommend adding or highlighting information on the risks I just described, including the risk of hostage diplomacy, especially as the PRC seeks to attract foreign visitors through its visa waiver program. However, protecting citizens from the risk associated with travel to China doesn't or shouldn't end at travel advisories. We recommend both an increased level of transparency and measures of accountability. I believe the Senate committee can play a continued role in both. Governments tend to be rather tight-lipped about the number of citizens detained in the PRC, the nature of the charges, the conditions detainees face, and the constant violation of consular treaties. An annual report to the Senate with respect for the privacy of detained individuals would provide greater clarity on the extent of the risks and duly call out the PRC for its unlawful practices. But transparency is only the first step. The PRC routine violations of consular treaties, use of arbitrary detention, and other discretionary restrictions on exit from the country must be met with concrete accountability measures. Targeted sanctions and visa restrictions are one way. We also strongly advocate a full review, and where necessary suspension, of police and judicial cooperation agreements, including informal ones. Not only have these demonstrably been abused by the PRC for its transnational repression schemes, they also continue to lend legitimacy to a system riddled with abuse. Finally, as during these hearings, this committee could continue to act as a platform for the family members of Australians detained in China to advocate on behalf of their loved ones. Whereas governments often seem to think quiet diplomacy will go a longer way with the PRC, our experience and those of the many we interviewed following their release is that treatment usually improves the more public pressure there is on a case. Safeguard Defenders will soon publish a practical guide for family members of those detained in China, and we would be most happy to share an advanced copy with the committee in the coming weeks. Thank you, and I'm happy to respond to any questions you may have.
Thank you very much, Ms. Harth. I might start with some questions to you and then go to Ms. Simons in a moment. Specifically on the issue of transparency around travel advice, I wanted to ask you about your thoughts on DFAT's Smart Travel website, specifically its advice in relation to China, which you've mentioned in your submission. Do you think the department needs to be more upfront with the risk of arbitrary detention on that website?
I do think there's issues they could highlight more. Now, compared to other countries, DFAT's advice is quite strong. However, I believe there's many issues that are not highlighted enough. And the fact that there's not enough transparency or reporting on what is happening to Australian citizens, as I mentioned, for example, through an annual report, I think may lead people to underestimate the risks.
You've also called for more awareness on residential surveillance at a designated location facilities, or RSDL. Could you outline what those facilities are used for?
So those facilities are used prior to arrest. While they are part formally of the judicial process, they happen before official charges are laid. The PRC uses them as a part of the investigation. Basically, it makes it more easy for them to obtain forced confessions, and that's what these institutions are for. So detainees are kept in secret facilities. Their whereabouts are unknown. They will have no access to lawyers. There is no real judicial oversight. They're placed under 24-hour surveillance in isolation. So everything is really geared and go through lengthy sessions of interrogations, again, to obtain those forced confessions. So they're effectively disappeared from the world, no notification to their family members. We have seen in the case of foreign citizens, there may be notification to the consulates, but also their access may be restricted. So all in all, these are really very serious human rights violations where, yes, confessions are extracted under torture, and which all international bodies have really called for their abolition. Now, we also see foreign citizens routinely go through this, especially in so-called national security cases. So this should really be included in any travel advice because it's a risk most people are not aware of.
And we heard from witnesses earlier in our hearing today, and I'm sure you weren't listening in because it would have been the middle of the night at your time, but we heard that oftentimes it's not until the point of getting a criminal charge that a person who is arbitrarily detained is provided consular access. So what you're saying is that when people are in these RSDL facilities in China, it is more likely than not that they are not being afforded consular access because apart from the fact that the reason they've been locked up is to extract a confession to a trumped-up charge, that there's not going to be any sort of formal charge at that point.
Exactly. They won't be charged until the RSDL period ends, which legally can't extend beyond 6 months. Sometimes it does, obviously, and it is likely that they may be denied regular access to the consulate, yes.
Sorry, you say that that period can't legally extend beyond 6 months. Is that according to Chinese law?
That is according to Chinese law.
In relation to China, what specific challenges need to be navigated when attempting to free an Australian who has been wrongfully imprisoned?
I think one of the first things is indeed that issue of transparency. So governments have a tendency of thinking quiet diplomacy may go a long way or a longer way to solve the issue. We don't believe that is necessarily the case. Obviously, the choice of the citizens involved and the choices of their family members involved needs to be taken into account. But our experience really shows that highlighting a case, speaking about it publicly, goes much further, at least in improving their conditions, especially when it concerns foreign citizens. Now, that does not necessarily lead to a more speedy release, as we've seen, because of the arbitrariness often of these charges, because of the what we call hostage diplomacy. The reason that the PRC often lays these charges, obviously they're tied to geopolitical or political reasons. So anything to speed it up very often would be, capitulating to whatever the PRC demands. So it's very hard, but I do believe if governments were more upfront about this, were more transparent about this, reporting about this more publicly, including to Parliament, that would impose some measure of accountability on the PRC. Just calling it out on its practices would make it clear for all what's really going on here.
And in addition to that accountability, do you also believe that making information and data in relation to wrongful detention cases publicly available can act as a potential deterrent to authoritarian regimes who are using hostage diplomacy?
Yes, I think in combination with other accountability measures, that could definitely act as a deterrent, especially if it can be done together, obviously, with allies and partners. So it would be great if Australia would lead the way to document that and publicly report on it. But the more pushback there is, the more transparency there is about this, I think the better. And it's a practice that we've seen democratic governments adopt more and more in other sectors that are related to geopolitics. So I don't see why that shouldn't be the case in this instance of, standing up for citizens of their own countries.
Are you aware of any data sharing amongst other like-minded nations on hostage diplomacy, or is it something that Australia will have to take the lead on?
I'm not aware of that happening. It's definitely not happening publicly. I wouldn't be surprised if there was some extent of data sharing, but not publicly.
Australia has Magnitsky sanctions at our disposal to target individuals involved in human rights abuses around the world. How can we ensure that Magnitsky sanctions are applied effectively and uniformly to those involved in hostage diplomacy?
The first thing, again, we go back to transparency, is obviously documenting what is happening and who are the people that are responsible for this. Now, civil society can play a big role in this, but unless there's certain data that's publicly available, compiled, for example, by governments, it's hard to often do that. Governments themselves, if they're not collecting information, if they're not making that publicly, might not be motivated to impose such sanctions. So again, we go back to the issue of transparency, which I really think is the first step, after which, once it's clear who are the people that are responsible or complicit for these violations, and I mean, we know what the institutions are, but once that first step is taken, I think everybody can advocate more effectively for imposing sanctions and visa restrictions, because one of the things that we as an organization are really appalled by is how these same institutions that are placing foreign citizens in RSDL, that are arbitrarily detaining foreign citizens, as well as obviously responsible for massive human rights violations inside China, routinely continue to have cooperation agreements with democratic governments, routinely continue to be able to send their officers to countries such as Australia to, engage in cooperation, but also, as we've seen, in unlawful activities. So this is really something that needs to be kind of brought together. And on the basis of bigger transparency, concrete measures need to be taken to put an end to it and, impose a cost on China and on those that are perpetrating these offences.
Ms. Harth, I'm sure you're aware that much has been said in recent years about Australia's relationship with China, and I think there is a view within some in the foreign policy space and more broadly in the community that often Australia will not call out poor behaviour by the PRC because we frankly called for an inquiry into the origins of the pandemic a few years ago and had a bunch of trade sanctions slapped on us as a result, and that has had a bit of a deterring factor in calling out problems in the relationship, for example, when our own citizens are being detained by the PRC. So how important is it for a country like Australia to be publicly attributing wrongful detention cases to China?
I think it's incredibly important. It's incredibly important to call out all unlawful behaviour, really, by the PRC. Now, Australia is not the only country that is often looking at, we need to stabilise trade relationships, or there's the geopolitics of things. And so the human rights issues very often are placed kind of in the background. Such are other issues that may cause tension with the PRC. I believe this is wrong. We see the PRC behaving increasingly aggressive, both at home and its domestic repression, that includes repression of foreign citizens. We see it engaging in hostage diplomacy. We see it engaging in aggressive military behavior with its surrounding neighbors, supporting Russia's war efforts in Ukraine. They're being quiet with China and thinking that somehow, if we don't make them lose face, things will be better and they will cooperate or be more cooperative in the future, I think has proven to be, not correct, a wrong policy. And so calling out their behavior, I believe, is clearly something they're very allergic to. Any organization working on China, any country that is outspoken on China, knows they get very upset and angry about it. But we've also seen that when things are called out, small changes, and I don't want to be overly optimistic here, but small changes do occur. And that goes from the treatment of individual prisoners when their case is being raised, to reviewing certain laws, or even people in institutions within China or within the Chinese Communist Party calling out certain practices because the issue has been raised internationally. And I think especially if they see that there is pushback on certain international cooperation, say judicial and police cooperation, because the system cannot be legitimized, I think we might see some changes. I'm not saying it will happen, but it would be possible. Definitely being quiet about it is not going to improve the situation as we've seen.
Completely agree. Thank you, Ms. Harth. Ms. Simons, I have some questions for you now. Your submission highlights the importance of communication between governments and families when a person has been arbitrarily imprisoned. And I was wondering whether you could provide to the committee some examples of both good and bad communication that you've seen in your advocacy.
Yes, of course. So examples of good communication would be regular contact and reliable contact, where DFAT sometimes hasn't been good at communicating is when they've left it for weeks before they're contacting the family, or in between contact, or when they have said they will contact the family and don't. Families put a lot of store by their contact with government. As I mentioned in my opening statement, they want to trust and work with government and understand what they're doing. They want information and reassurance from their government. And when that communication is intermittent and not reliable, that undermines their faith in what government are doing and the priority they're giving to their case. So that's one area of communication that is really important. The other aspect is having people in the role who can actually answer the questions that the family has, so that the family have confidence that they're speaking to people who know what their job is and what the issues are and the complexities of the case. Where that's lacking, the families are lose faith in their government.
A number of witnesses have already spoken about the benefits of dedicated caseworkers to assist families in their time of need. Could you provide your thoughts on how this could best be implemented?
Well, in all cases where there's an incident, a consular incident, then most families are given a dedicated caseworker. From what we've seen, I mean, that is the norm. They have a contact within government. The problem is the nature of that contact. That contact's often quite a junior person who, as I mentioned, isn't able to answer the questions that the family has, and that's why they frequently ask, "Can I speak to the foreign minister? Can I speak to the prime minister?" And of course, that doesn't happen. It can't happen on a regular basis, and it wouldn't be appropriate for it to. It would be appropriate for that to occur in certain circumstances. But that means that the person that they are speaking to on a regular basis does need to be more senior or have the authority and knowledge. And that's why in my opening statement, I referred to the need for someone who is accountable and senior, such as a special envoy in the United States or the SOHA in Canada.
I also note that your submission mentions the pros and cons of family using the media to advocate for the release of their family members overseas. Do you have a view on whether government should be providing advice to families or potentially even media training for families who want to advocate publicly for their family member? Because it seems to, very much be a case where DFAT says, no, please don't go to the media and advocate for your loved one overseas, and then families find themselves in a position of frustration. They go to the media, and we've had testimony to this committee that it doesn't always achieve the best outcomes for the person who's been detained overseas, mainly because of the manner in which that advocacy took place.
It's a very good point. I don't think DFAT say families shouldn't go to the media in those terms, and a lot of governments are now careful not to be. To prevent families from going to the media. That's not their role, and they won't do that. But DFAT will be very careful to set out all the risks, but not necessarily any benefits. And the point is that again, coming back to my point, that the people that are talking to families aren't experienced enough to know that there are nuances in using the media. There are times when media might be effective. There are no cases where there is at no point a time where media is harmful or there are points where it could be beneficial. And it's having the knowledge and understanding of the cases and the complexities and the trajectory of a case to know when those pressure points can be applied. And Laura raised the point several times, which we agree with, that media could be useful in improving the treatment of the detainee. And we've seen where we've seen governments work well with families has been where they've been open about the risks and the benefits and have said, look, if you want to go to the media, and not all families do, and that's absolutely fine, and that should be respected as well. But where they do, because they need that agency, they want to feel that they're doing something for their loved one. And indeed, if the loved one, the detainee, is also putting pressure on the family to do that, then one thing that families can do is focus on the humanitarian conditions of the detainee, the treatment they're receiving. Maybe they're in solitary confinement, maybe they're ill and haven't been seen by a doctor. Maybe they're not getting proper food. These are things that can be highlighted in the media without too much risk, because it's not pointing a finger at any government. And that's where governments can work well with families and, in a sense, use the media to try to improve the conditions of the detainee. And anecdotally, we have seen benefits from that type of media exposure. But if a government has that relationship with the family where they can talk about, yes, we will support you. We will give you some training. If you want, we will help you write the press statements that you need. And they should be doing that, because actually in any detention case, those leading on the operational response side, in other words, the resolution, should always have input into any media, because only the government in an arbitrary detention really knows what's going on behind the scenes. So we'll know what will be risky and what won't be. It is essential they work with families to do the media exposure, and that if they do that, when the time comes and it is sensitive and risky to go to the media, the family will listen to them.
Yeah, I think that's a really good point, and I haven't necessarily heard it articulated that way, but that's really useful to know. In your submission, you reference that sometimes the Australian government does pay for repatriation costs for Australians returning from being wrongfully detained overseas, and in other instances they do not. Do you have a breakdown of numbers of how many have their costs paid versus those who don't?
No, I don't have that figure. I just am aware, because I know a number of the former detainees and hostages who've given me their own perspective on what's happened, and there's been a mixture of those who've had their costs fully paid and those who haven't, and there doesn't appear to be any reason why there's that distinction. The only one I could possibly think of, and I don't think this is unique to the Australian government, unfortunately, I've seen it in other countries as well, is if it's a high-profile case and has had media attention, then the costs are more likely to be paid.
Mm-hmm. That's interesting to know. What more can government do to provide for the physical, mental and legal needs of detainees post-release?
It's a really good question, and I'm very conscious that Ministries of Foreign Affairs have a remit to help, and in the case of DFAT, help Australian citizens when they're in trouble overseas, and when they come home, that their remit ends. And very few governments, foreign ministries in particular, will provide much support beyond release. So that is normal, and I don't see DFAT's response being any different from most other governments. However, other governments do provide more support in terms of financing, perhaps, the treatment and care that the returnees receive, because it is costly. And they either do that by funding other NGOs to provide that, to fill that gap, or they'll reimburse the costs of the care that returnees receive. So those are two aspects that I think DFAT should be looking at: is how are those costs addressed, but they should be more aware, I think, of what is available and who to signpost to, because basically, at the end of a case, what the government should be doing upon release is ensuring that there is a psychologist present at the point of release to brief the returnee, because only at that point they're the only ones who have access at that point to the returnee. NGOs don't have access at that as the individuals getting off the plane, but DFAT do, and they should have someone present who can provide information to the returning detainee about the psychological impact and what that might look like over the coming weeks and months. It's too early to do an assessment for PTSD. That comes later, and so government can't take on that responsibility, but they can provide someone to do the firefighting at that stage and just make the returnee feel more secure that all the mixed emotions that they're going through are actually a normal part of the response to the trauma they've been through. But after that, they should then be signposting the returnee and the family to NGOs who are well equipped to provide long-term care, because if they start to provide care, and I mentioned that I think in the case of Chang and Sean Turnell, they provided 4 sessions, that's good because they're funding it, 4 sessions of therapy to those returnees. But if they can't go beyond that, what happens is that after 4 sessions, more are needed, and they've built a rapport with that psychologist, and they have to start afresh. So actually that isn't very helpful. It would be better to hand over immediately to NGOs who are better placed to provide the support consistently and through the right people, because we and other NGOs in Australia with whom we work have psychologists who are trained trauma therapists and have a knowledge of the impact of captivity. So but where governments can provide better support, and I really think this is important, is in the practical support that they give to families on return. They can write supporting letters to confirm that they actually had genuinely been in a situation of arbitrary detention or wrongful detention. This can be helpful when they're looking for jobs. It's also important for travel. We've heard from some of the witnesses talk about the travel bans that they're under because of the detention that they've experienced in whichever country. And governments, I think, have an important role in trying to help their nationals be able to travel safely and without impediment following an incident. So that's one area of practical support that they can provide. And there are plenty of others, but I think that if they think about the needs and talk to NGOs about the needs that returnees have, then working with NGOs, they can determine what they're better placed to provide in that practical space especially, but also in terms of funding for longer term care, and work together with NGOs in Australia to make sure that's effective.
Thank you very much, Ms Simons. Just one question quickly from Senator Cadell.
Question for you. We've had evidence today about which countries do the or the systems better within foreign affairs, defence and trade, like America, and Canada is considering their system now. On repatriation and care for those affected by wrongful detention, arbitrary detention, do any countries do it better that we should be looking at their models currently? Because in Australia, you get your 4 appointments, but I think any Australian under a mental health plan would get more than that. You get 5 visiting your GP. So are there countries that do repatriation better?
I think there possibly are. I don't know enough about the US repatriation because that's the one country Hostage International doesn't operate in, where our sister charity does, and so I would lean on them to respond to that. But I think where it's been better looked at, and I think the Canadians have been looking at this very carefully, and they're very conscious that they aren't perhaps doing enough, but also aware that their remit ends when the Canadian national lands in Canada, are looking at better funding. They have a fund that is available to both the families and the returning nationals, the returning hostages and detainees, and that fund is available to both the families and the returnees to pay for the costs of psychological treatment, dental treatment, it could extend to other things as well. And I think that's a really important, because not everything's covered by insurance. They have an medical insurance system as well as Australia does. But as you know, specialist psychologists, trauma therapists may fall outside of that. And it needs to be speedy access. And so having a fund available for nationals to to reimburse their costs would be extremely beneficial. In other cases, as I say, NGOs are given the funding to make sure that they can actually stand alongside the family and the returnee to help them access the right services as well as cover the costs, and that's even better.
Okay, thank you, Chair.
Thank you very much, Senator Cadell, and thank you, Ms Simons and Ms Haas, for appearing for the committee today. We have a due date for responses to questions on notice of Friday the 1st of November. I don't think any of you took them, but if you did, that's when they needed to be provided to the committee. That includes today's hearing. Thank you to all of the witnesses who appeared and to Hansard and Broadcasting for their assistance, and the committee stands adjourned.
Thank you.